Aloha mai kako and good morning. This is the December 22nd, 2021 Land Use Commission meeting, which is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing platform. Of course, to comply with the state and county official operational directives during the still ongoing COVID-19 pandemic, members of the public are able to view the meeting via the Zoom webinar platform. For all meeting participants, I want to stress the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, it is helpful if you state your name to identify yourself for the record. Also, please be aware for all meeting participants, this meeting is being recorded. Your continued participation is the implied consent, your implied consent to be part of the public record for this event. If you do not wish to be part of the public record, you should leave the meeting now. This Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting via our own personal digital devices. Because of that, due to matters often entirely outside of our control, occasional disruptions to connectivity may occur. If this does occur, please let us know, and please be patient as we try to restore audiovisual signals so we may continue to conduct business during the pandemic. For any members of the public attending who wish to testify on any matters where public testimony is allowed, if you're calling in by phone, you can use the *9 key sequence to raise your hand. Otherwise, members who are accessing this via Zoom software can use the raise your hand function. We will take breaks from time to time, approximately 10 minutes every hour. My name is Jonathan Likeke Scheuer, and I currently have the ongoing honor and pleasure as serving as the Land Use Commission Chair. We currently have 8 seated commissioners of a possible 9. Along with me, Commissioner Don Chang, Commissioner Arnold Wong, our LUC Executive Officer, Daniel Ordenker, our Chief Planner, Scott Derrickson, our Staff Planner, Riley Hakoda, our Chief Clerk, Natasha Quinones, and our Deputy Attorney General, Linda Chow, are on the island of Oahu. Commissioner Nancy Cabral is on Hawaii Island. Commissioner Leo Higashi holds it up for us on Maui, and Commissioner Dan Giovanni is on the island of Kauai. Court reporting transcriptions are being done from this Zoom recording. I will note for today regarding attendance, Commissioners Okuda and Axon are excused from today's meeting. Our first order of business is adoption of the November 10th and 23rd, 2021 minutes. Ms. Quinones, has anybody submitted written testimony regarding adoption of the minutes?
Good morning, Chair. This is Natasha. No, there's no written testimony has received.
Okay. Thank you. Is there any member of the public who wishes to testify on adoption of the minutes? If so, use the raise your hand function. Seeing none. Commissioners, are there any comments or corrections on the minutes? If not, is there a motion to adopt? Commissioner Wong?
Chair, this is Commissioner Wong. I move that we adopt the minutes, both minutes.
Okay, Commissioner Cabral?
I'll second that motion for both sets of minutes.
Thank you. Motion's been made by Commissioner Wong and seconded by Commissioner Cabral to adopt both sets of minutes from the November 10th and 23rd meetings. Any discussion? Seeing none, Mr. Ordenker, please poll the commission.
Thank you, Mr. Chair. The motion is to adopt the minutes. Commissioner Wong. Aye. Commissioner Cabral.
Aye.
Commissioner Chang.
Aye.
Commissioner Giovanni.
Aye.
Commissioner Ohigashi.
Yes.
Chair Scheuer.
Aye.
Thank you, Mr. Chair. The motion passes unanimously with 6 votes.
Thank you. Our next agenda item is the tentative meeting schedule. Again, Mr. Ordenker.
Thank you, Mr. Chair. Tomorrow we will once again be meeting to hear continuation of this matter if necessary. and to hear the Keikaha Agricultural Association IAL matter. The Toronto meeting will also be present. I should let the commissioners know that due to high COVID counts that we've recently been subjected to, that it's our intention, at least through the end of January, to hold meetings by Zoom.
Mr. Ordenker, you're breaking up a little bit. I'm not sure why.
Disclosure Chair. On January 5th, we will be having a presentation from the OPSD Sustainability Coordinator. On January 6th, we
Whoa,
will.
whoa, 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 whoa. Somebody's moving papers next to a microphone or something. Sorry. It was kind of deafening. Sorry, I apologize again, Dan.
Okay, thank you, Mr. Chair. On January 6th, we will be taking up the Oahu IAL matter. On January 19th, we have SB 21-413, which is New Century Public Charter Schools Special Permit. We will also be hearing that matter on January 20th with possibly DR 21-72, a motion for reconsideration in the church map. On February 2nd, we will have a hearing on, once again, on the New Century Public Charter School matter. And if possible, and if necessary, a hearing on the continued hearing on the Oahu IAL matter. The same for February 3rd. And on February 16th, we will be having a hearing on the acceptance of the FEA for Puamano Lanai, Pinky Basin. And on February 17th, we will also be taking up that matter, as well as Kaukona Ua Ranch. On March 9th, we will be hearing DR 21-72, which is the Church Hildell matter. On March 10th, we also have set aside, if necessary, continuation of the Oahu IAL matter and the Kaukona Ua Ranch matter. On March 23rd, we will be taking up the Waiawa Solar Farm matter, and on the 24th, we will be taking up the FEIS acceptance for AO3739, which is the Kanaha Hotel. April 13th, we have a continuation of the Waiawa Solar Farm matter, and we also have that penciled in for April 14th if necessary. And then that takes us through the end of April. From there, the calendar is tentative. Thank you, Mr. Chair.
Thank you. And I believe you said at the beginning, when your audio was a little bit off, that due to the increasing case counts, we're intending to meet virtually at least through the end of January. Is that correct?
That's correct, Mr. Chair.
Okay. Commissioners, are there any questions? Seeing none? Oh, Commissioner Giovanni. No? Okay. Any other questions or any questions, commissioners? Seeing none. Thank you very much, Dan. Our next agenda item is an action item regarding docket number DR 2173, HONOIPU HIDEWAY LLC, Hawaii, to consider a petition for a boundary interpretation for certain lands consisting of approximately 17.5470 acres situated at 56102 Old Coast Guard Road, tax map key number 35-6-001-074, Kapa'a Upolu, North Kohala, County of Hawaii, State of Hawaii. Will the parties please identify themselves for the record, beginning with the petitioner?
Morning, Chair, Commissioners, Cal Chipchase, Chris Gooden, and Molly Olds for the petitioner, HONOIPU HIDEWAY.
Thank you. County of Hawaii, you're with us?
Yes, Jean Campbell, Deputy Corporation Counsel at the County of Hawaii.
Okay, thank you, Ms. Campbell. Ms. Kato?
Allison Casso, Deputy Attorney General for the Office of Planning and Sustainable Development. Also here are Lorraine Maki and Mary Alice Evans from the Office of Planning and Sustainable Development. Thank you.
Thank you very much. Let me next update the record. On June 25th of 2021, we received a petition for a declaratory order for a boundary interpretation, a verification of the petition, petitioner's exhibits 1 through 26, and a certificate of service. On June 28th, the commission received the petitioner's filing with a cashier's check for $1,000. On September 8th, the petitioner filed the survey of the subject property reflecting the location of the conservation district boundary line along the edge of the road. On September 14th, the County of Hawaii filed a statement of no position and notice of non-appearance. On September 15th, the LUC staff sent an errata letter to the petitioner. On October 11th, the commission received the petitioner's response to the errata letter. On December 6th, the commission received the petitioner's supplemental memorandum in support of the petition for declaratory order, a declaration of Nathan Egan and Miles Horie, exhibits 1 through 32, and a certificate of service. On December 13th, the Office of Planning and Sustainable Development filed its position on the petition for declaratory order, exhibits 1 through 4, and a certificate of service. Also on that date, the commission mailed and emailed the meeting agenda for the December 22nd and 23rd, 2021 meetings to the parties in this docket and to our statewide and county mailing lists. On December 16th, the petitioner filed a supplemental exhibit list, exhibits 33 through 34, and a certificate of service. And this morning, the commission received a petitioner's late filing of a supplemental exhibit list, exhibits 35 through 39, and a certificate of service. Have I left anything out, petitioner?
Chair, the only exhibit that you left out, I believe, was filed this morning. It's exhibit 40.
Okay. It's hard when they're last minute, Counselor.
I understand, Chair. I absolutely do.
It does create a burden for the staff and the commissioners.
I respect that as well.
Let me briefly now run over our procedures for the docket. First, I'll give the petitioner an opportunity to acknowledge the commission's policy governing reimbursement of hearing expenses. Then I'll acknowledge any written testimony that has been submitted in this matter. I'll then allow for any public testimony from members attending. After the completion of testimony, I will, from the general public, I will allow this county and then the state to offer any testimony if they will. Following their testimony, I will call on the petitioner to make their presentation. After that, I will ask for any questions from the commissioners. If there is time available, I may offer the commissioners to ask any further clarifying questions from the county or the state, and any opportunity to rebut or further clarify from council. And finally, based on the information received today, the commission will determine further action. Are there any questions on our procedures for today? Mr. Chipchase?
No, Chair.
Okay. Ms. Campbell? Ms. Campbell, it is an audio recording of this record, so you're shaking your head even vigorously.
No questions. Thank you.
Thank you. Ms. Cotto?
No questions. Thank you.
Thank you. Okay, so to move on, Mr. Chipchase, can you acknowledge that you've reviewed HAR 151545.1 with regard to the reimbursement of hearing expenses and state your client's position on the matter?
Yes, Chair. Reviewed, acknowledged, and accepted.
Okay, thank you. Ms. Quinones, is there any written testimony submitted on this matter?
Yes, Chair. We received written testimony from Marcel Lauren and Linda and Marty Colbrader.
Okay.
Also, we received testimony from Quisera and Stephen Smith.
Thank you. And are those posted to the website now?
The first two are the last one is not posted yet, but I will post later on today.
Thank you. Starting with the individuals who filed written testimony, if they want to file any supplemental oral testimony, raise your hands. If not, are there any members of the public who wish to provide oral testimony on this matter? If so, use the raise your hand function. I am able to see that no one is calling in, so just the raise your hand function in software. Okay, I am seeing no public testimony from the general public on this matter. I will now invite the county to share any testimony that they wish. Ms. Campbell.
Good morning, Chair and Commissioners. I am Jean Campbell, Deputy Corporation Counsel at the County of Hawaii. You've previously received the county's statement of no position with regard to this matter. It's the county's belief that a determination regarding changes to state land use boundaries is the jurisdiction of the LUC and not the county. Thus, we believe that this matter is properly before the LUC for your determination. The county will defer to your determination. I'm simply attending today's hearing to be available to answer any questions should you have any. Thank you.
Thank you very much. Are there any questions for Ms. Campbell at this time from the commissioners? Seeing none. Ms. Cottle for the Office of Planning and Sustainable Development.
Thank you, Chair. I do have comments. It should only take about 5 minutes or so.
Please proceed.
Thank you. The Office of Planning and Sustainable Development does not support petitioner's requested declaratory order determining that the location of the state land use district boundary line was incorrectly situated by the LUC's boundary interpretation. Petitioner argues that the LUC should determine the boundary line is located along a currently existing paved road that curves through the property. OPSD does not, however, find sufficient reason to believe that the current official boundary is incorrect or that petitioner's alternate interpretation is instead the correct one. The official map, sorry. The official map establishing the location of the conservation district boundary for this particular property was adopted by the LUC in 1969. And this is the currently existing boundary that's on the LUC's boundary interpretation. It's identical. Subsequently, a report from the 1969 LUC boundary review was completed, which was not adopted by the LUC, but it does include a record of the LUC's actions and information on how the boundaries were set. The boundary review report did not clearly state or map out in detail where the boundary for any particular land was located. Instead, the report contains broad descriptions of large sections of the coastline. For this particular area, the report states that the area is marked by numerous historic artifacts and a variety of conditions that should be included in the conservation district, so it was pretty inclusive. The report also contains 4 conditions that guided the setting of the boundaries. 3 of the conditions describe physical boundaries that can be used, such as a road or vegetation line marking the edge of agricultural use. So, in other words, where there was some physical feature dividing the agricultural use and the non-agricultural use. And the last condition was a general 300-foot setback. Petitioner has provided evidence that a road and some buildings were constructed on the petition area in 1961 as part of major Coast Guard station reconstruction, and that these are not present on the 1969 LUC map. But OPSD is not convinced that the unmapped road is relevant to determination of the boundary line. The boundary line appears to run across the property behind the Coast Guard buildings that were constructed malka of the paved road. So OPSD does not know the specific reason for the current location of the boundary line, whether it was due to a road, a vegetation line, the Coast Guard station, or some other identifiable boundary, or the 300-foot setback. But the boundary on the 1969 LUC map was a result of various sources of input and the official action of the LUC in 1969. OPSD assumes that the present location of the boundary that was adopted by the LUC in 1969 is correct, unless proven otherwise, and relies on the records and findings of the LUC. Addressing petitioner statements that the paved road meets condition 1 and should have been used to draw the boundary. The fact is that the boundary was not drawn there. It was clearly drawn inland and not based on any dirt road running through the property, as the pre-1961 dirt path mentioned in the petition did not even run through the property parallel to the coast, which is shown in OPSD's exhibit number 4, where the location of that dirt road actually went into the property. It kind of went along the side. Even if the paved road had been shown on the LUC map, condition 1 is a road that marks the end of agricultural use. And this road does not appear to be at the edge of agricultural use, as there are Coast Guard crew housing buildings built malka of the road. So OPSD has not seen clear evidence that Mauka of the road, there was agricultural use. OPSD does not believe there is sufficient support to determine that the boundary shown in the 1969 LUC map and the LUC's boundary interpretation number 01-20 are not accurate, or that should be changed. For these reasons, OPSD does not support this petition for declaratory order for boundary interpretation. Thank you.
Thank you very much, Ms. Kato. Commissioners, are there questions for the Office of Planning and Sustainable Development? Commissioner Ohigashi.
Thank you, Mr. Chair. I was just wondering, your exhibit number 4, can you tell me, because my glasses are a little bad today, what's the source of exhibit number 4? I think I know, but
Okay, the source of exhibit 4 is basically we asked GIS to show a comparison of the USGS topographic maps dated in 1957 on petitioner's current survey map. So it's basically a combination of the two maps. That's why the lines are a little off. They didn't exactly meet precisely.
Sorry, for the audio transcript, Ms. Kato, you said you asked whom to do this?
GIS
GIS.
or
Thank you.
Office of Planning.
Thank you. Sorry to interrupt.
and this exhibit 4 shows a pink paved road. And that is the 1982 paved road, according to the 1982 topographical map. I'm not sure if I'm making it pink or,
Sorry, yes.
I think it's pink. And there's a solid blue line showing the Conservation Agricultural District boundary.
Yeah.
And the green line is the 1957 dirt road.
Yeah.
Okay, and that is shown.
Yeah, that's a
topograph-
combination of 3.
That's shown in the topographical map of 1957.
Yes, that's my understanding.
So- Was there? I seem to recall, and I don't have it all in front of, I don't have it all written down in front of me to ask that question, but I was wondering, are any of the so-called maps utilized by the petitioner in this matter exhibited on your exhibit 4? In other words, any of the specific maps? I think it was a 1964.
Sorry, I'm not sure which maps exactly are you referring to? The USGS maps that we used for this map are used by GIS. I'm not sure if petitioner used them or not.
I don't have any questions more. I just wanted to clear that up.
Thank you, Commissioner Ohigashi. Commissioners, further questions at this time for OPSD? Commissioner Chang.
Sorry, there I raised my hand. This may not be, I'm not sure if this is relevant or not. I couldn't find any information in the record. But Ms. Kato, is there any evidence that that the dirt road is an old government road?
We actually could not determine what this dirt road was or that it even was a road exactly. A petitioner provided a map that indicates that it might be a Jeep road, but we're not sure what it was or that it actually existed. At first, we thought it wasn't a road, but
Yeah. I'm just wondering, pursuant to the Highways Act of 1892, if this was an old government road, then actually the state of Hawaii may still own that. So, and it may have cut through this property. But I just could not find any information in the documents that were provided to confirm the date of the road or get any maps old enough to show, so, okay, I was just curious whether this was an old government road that ran Mauka to Makai. Okay. All right, thank you.
Thank you, Commissioner Chang. Commissioners, further questions at this time for OPSD? Seeing none, we're good for now, Ms. Kato. Thank you
Thank
for your
you.
presentation. We'll now move on to the petitioner's presentation. Mr. Chipchase, are you ready to proceed?
I am, Chair. I just need to share my screen if that's all right.
Yes, please.
All right. Good morning again, Commissioners. Cal Chipchase for the petitioner, and happy holidays. Commissioner Ohigashi and Commissioner Chang will address your questions in our presentation. I'll go over Exhibit 4 in particular, and Commissioner Chang, I'll do my best to address your question now. The road that was constructed in 1961 was built by the federal government. The older road that is shown on the maps, I do not know its origin. We also looked for that, but we're unable to determine conclusively when or who that road was developed. We are here, as you heard, for consideration of our petition for a district boundary interpretation. The petition asks the commission to determine the location of a district boundary line that runs through our property. This is a recognized process that is set by established commission rules. In 1969, the commission conducted a comprehensive review of the land use district boundaries, and that's when the conservation district boundary for this property was first mapped. Prior to 1969, the conservation district line had not been mapped for this property. As the commission explained in that review, that 1969 review that led to the mapping of the conservation district boundary on this property, future commissions should, quote, continually strive to improve and to clarify the district regulations and district boundaries so that the inconsistencies and ambiguities are removed when identified, rather than waiting for the 5-year program. And so the commission, when it did this really comprehensive, wide-reaching work, recognized that the work would not be perfect, that there would be inconsistencies, that there would be ambiguities, and in its own report, encourage future commissioners to address those. Consistent with that commission's recommendations in 1969, the rules are set up so that this commission, future commissions, can make those corrections, can make those adjustments. Our petition comes to you having followed that process. We first worked with LUC staff to both correct the interpretation and to identify the correct procedure for bringing this matter to you if we were unable to correct the interpretation at a staff level. To do so, we requested a staff boundary interpretation. We ultimately received 2 of them. Both interpretations put the boundary line in the same place on the map. Both interpretations followed the same line, but the reasons given for putting the line in that same location were inconsistent. One reason was given on the first interpretation, a different reason was discussed or provided in the second interpretation. We discussed those interpretations with staff, very grateful for their time, both in working on the interpretations and in meeting with us. And we discussed the best way to correct what we believe to be a mapping error from that 1969 review, what we believe to be the kind of ambiguity and mistake or irregularity that the commission was talking about. Ultimately, a petition for declaratory relief was determined to be the appropriate process. That process is set out in HAR 1515-22F and 1515-98A. Section 22F provides that, quote, whenever subsections A, B, C, D, or E cannot resolve uncertainty concerning the location of any district line, the commission, upon written application or upon its own motion, shall determine the location of those lines. And of course, section 98 is the basic declaratory relief section. we'll talk about those provisions later in our presentation. As we're set to begin, Chair, I'd ask that the commission accept our exhibits 1 through 40 into evidence. And additionally, we will provide this PowerPoint presentation to the commission and would label it Exhibit 1. I ask that the commission receive that exhibit into evidence as well.
Mr. Chair, I haven't received exhibits 39 or 40.
Yes, I was going to bring that up. Some of these were received very late. So it's the commission's pleasure, Chair, ultimately, but I defer to the commission on whether or not to accept all of these exhibits. What's the commission's pleasure? Mr. Ohigashi?
Well, I'm inclined to receive up to 38, which I can review, but we'd like to review 39 and 40 these before formally accepting them. I'm not sure if filing means.
Natasha?
Hi, yeah, Chair, this is Natasha. I think there's a confusion. I do not think we received exhibit 40. We did receive exhibit 39 and no, 35 to 38, and then also 39 separately, but there's a link and it's a quite large exhibit, so I couldn't load it. And I'm trying to figure that out as we speak, but exhibit 40 was not received, so maybe there's a confusion there.
Okay. Oh, 39 was what was sent in today. Sorry, are you still speaking to us, Natasha?
No, I'm not. I'm done.
Okay, we're picking up your audio, however. Mr. Chip Chase, is your arguments today dependent on having all of your exhibits?
Chair, if I may make a correction, actually, Ms. Olds is correcting me. Staff is correct. It's exhibits 1 through 39.
Okay, you corrected me earlier that you said you had a 40th, but so 1 through 39?
My fault entirely, Chair.
Okay.
1 through 39. 39 is a copy of that 1969 commission review. So it is a state record.
Hold on, Counselor. So I'm sorry, looking at my list again. The timely filings that we received were from, one moment, through exhibit 34. On December 16th, we received exhibits 33 through 34. Now we've received 35 through 39. Are you able to stop screen sharing on your presentation?
Yes,
and
Chair.
Screen share what those exhibits are?
35 through 39, Chair?
Yes, please.
Yes. If you'll give us a moment, we'll pull those up.
Just email them to me.
What's that? Let's go up to the list. Yeah. Do that? Yeah.
Mr. Chip Chase?
Mr. Gooden is just about to share it, Chair. All right, Chair. Commissioners, on the screen, I've put our exhibit list, the supplemental, that lists 35 through 38. We can scroll down and view those as well if you'd like, Chair.
Yes, please. So read out the 35 through 38.
Yes, Chair. 35, 1969 review, agricultural uses map, TMK overlay excerpt. 36, 1969 review, agricultural uses map, TMK overlay. 37, 1954 USGS aerial excerpt, TMK overlay. 38, 1954 USGS aerial TMK overlay. And Chair, if I'm not mistaken, and Ms. Olds can correct me if I am, it happens. These were prepared in response to OP's comments that some of the locations of the property on these larger maps was not sufficiently clear. Chris, if you would scroll down, please. All right, so this is Exhibit 35, Chair, the excerpt that we identified. Keep going, Chris. Keep going. 36, Chair. Again, from the 1969 review. 37, Chair. And 38, Chair.
Okay. If you'd stop screen sharing for a moment, please. So unlike some recent filings, OPSD filed on December 13th. I really believe it's at least on appearances, there was more than adequate time to respond to it in a timely way. Do you have some sort of extraordinary or compelling reason, Mr. Chipchase, that these exhibits were filed so late?
When were these filed?
They were filed yesterday when we received them.
Ms. Olds informs me that we filed them when we received them from the surveyor, Chair.
So the dilemma, and so this is to tell the commission my inclination, but I want further feedback from them. The very late filings puts us in a very awkward position. If we accept them and say we rule against you, you can always argue that we perhaps didn't fully take into account the information that was provided to us. It's my inclination to not accept them because honestly, receiving them at the last minute, we don't have a chance to fully review them in the light of the record. What is the commission's inclination? Commissioner Higashi.
I support the chair.
Commissioner Giovanni.
I support the chair's inclination.
Commissioner Chang.
I too support the chair's inclination. I think if it was dispositive to the petitioner's case, knowing Mr. Chipchase, he would have included it in his original exhibit. So I support the chair.
Okay. I'll allow you another chance to respond, Mr. Chipchase, before I determine acceptance.
Very good, Chair. I appreciate that opportunity. I would say this, Chair, obviously would waive the argument that you hadn't had sufficient time to consider the exhibits if you deny our petition, right? I can make that representation on the record and at least resolve that portion of the chair's concerns. As far as the documents themselves, we will review them in the PowerPoint presentation. And so there will be an opportunity to see and to study the exhibits, which acknowledge the late filing, but ultimately the quest here is to determine the facts and to have as much evidence before the commission as possible in determining those facts. We believe those filings are relevant and are responsive to comments that OP made. And we filed them as soon as we were able to after we received them from the surveyor, which of course would take some time to prepare. So while I completely understand and respect the burden and the position that it puts both the commission and the staff in when we file late exhibits, it does happen sometimes. And I believe in this case, the reasons are sufficient and the exhibits themselves are material to the commission's determination.
Is exhibit 37 and 37 or 38 the same as your exhibit 9, except with the overlay?
Yes, Chair.
I'm inclined to accept exhibits through exhibit 30. Let me get this right to be really clear. To not accept the late exhibits, but to accept exhibits through 34. Commissioner Chang.
Mr. Chair, if I may, those additional exhibits for the late filing, is it possible to consider them at the time after Mr. Chipchase has presented?
Yeah, I would entertain a motion by him after his presentation to include them.
Yeah, because I do want to give him the full opportunity to present his case in his best light, since he's the petitioner. So that's my thought to you. Thank you, Mr. Chair.
Okay.
So you're going to, so essentially you're reserving ruling on those particular exhibits.
That's correct. Commissioner Cabral.
Yes, thank you for, I think we're resolving this. I find that I'm a very visual person, and I find the maps most interesting for me with my experience and background. So I appreciate the ability to be able to look at those and hope that they won't be then, if you folks could work it out, your lawyer types, to where they don't become a liability to us for the ability for us not having had them earlier, because I printed all my little maps in color so I could see all this stuff. So I appreciate that. That's what I like to see. So I want to know all the information I can visually. So I appreciate the ability to work through this. Thank you.
Okay. So I'm accepting through 34, and I'll let you bring a motion for the additional ones at the end of your presentation, Mr. Chipchase.
Very good,
Are you
Chair.
ready to continue?
I am.
And we'll go for about how long is your presentation, Mr. Chipchase?
The total presentation, Chair, is about 2 hours.
I did not notice any inflection of joking in your voice.
If only that were true, Chair. It is about 2 hours, including the testimony of one witness.
Okay, so why don't you go for about 10, 15 minutes, then we'll take our first break.
Will do, Chair. So as we were running through the rules 15, 15, 22, and 98A, I noted that we'll talk about those in a little more detail later in the presentation. Right now, we'll start with the location of the property, putting these things into context. A petitioner owns the subject property located at 56-102 Old Coast Guard Road in North Kohala. The property is about 17 acres. And as you can see, the property abuts the shoreline. On the screen, we've put up on the left a recent GIS aerial of the property. And on the right is an overlay of the conservation district in the larger area. To the north of the property, the conservation district boundary line follows the edge of the road that runs along the coast, except in areas of historical, recreational, or other significance. Generally, the land Malka of the road is in the agricultural district, and the land Mackay of the road is in the conservation district. The boundary line separating the conservation and agricultural districts in this area, as I mentioned, was first drawn in 1969. And this brings us to the maps. Commissioner Ohigashi had mentioned the maps that we had cited. This brings us to the 5 maps that we will focus on most through our discussion today. The first map is the 1957 USGS map for the quadrangle. And Commissioner Ohigashi, it is on that map that the road appears. The road obviously existed before the map. It wasn't built in 1957. That date on OPSD's Exhibit 4 refers to the date of the map. That 1957 USGS map served as the base map for the 1964 LUC H3 map for the quadrangle. And that's the second map that we've put up on the screen. This was the map that the commission used, the 1964 commission used to draw the agricultural land use district. The 1964 map was then used in the 1969 LUC map to draw the district boundary line separating the conservation and the agricultural districts. And as you can see, this 1969 map was the first time that the boundary line for the conservation district was drawn on our property and in the surrounding area. Generally, this line, this conservation district line, follows roads where they exist within a reasonable proximity to the shoreline. Land Malka of those roads is in the agricultural district. Land Mackay of those roads is in the conservation district. The fourth map is the 1974 LUC H3 map for the same quadrangle. This map is a republication of the 1969 map for the line separating the conservation and ag districts. In other words, the location of the boundary line on the property did not change from 1969 to 1974. The commission just republished the map. And the final map is the 1982 USGS map for the same quadrangle. This map shows the road that we will discuss today in the current location or through the current location of the property. This road, to Commissioner Ohigashi's question earlier with respect to OPSD's Exhibit 4, was not built in 1982. As we'll explain today, it was built in 1961, but it was depicted on the USGS map from 1982, and that's where that date comes from. We've generally circled here, you can see the location of our property on the map in relation to that 1961 road. We've put up the current survey of the property on the screen for the commission. The property is about 17 acres. And this survey depicts staff's interpretation of the conservation district boundary line. And that's the dashed line that we indicate here. That's the current.
So I'm just gonna interject here, Cal.
Yes.
If you really are going to use a full 2 hours, it would greatly benefit at least this commissioner that you lay out what the overview of your presentation is going to be, so I know where we are. You will lose me.
I understood, Chair. And I believe, is that our next 2 slides from that, Chair? I was just trying to give an overview of the property.
Okay. Why don't we go through your overview of the presentation, then we'll take a break.
Very good, Chair. So if I can just finish up with this slide, Chair, and then we'll quickly get to the overview. The survey also shows the road running through the property that we looked at on those other maps. We've indicated that here with the arrow. As I mentioned, this road was developed in 1961, 8 years before the boundary was established by the LUC. We asked for staff's interpretation of the boundary line, and staff's first interpretation concluded that the boundary line followed a trail or roadway. Following a trail or roadway, as OPSD mentioned today, was one of the LUC's guidelines in the 1969 review. Indeed, as we'll see, it was the very first guideline. The LUC staff then set the boundary along the roadway, following or using the shoreline survey of the property and the district boundaries map for the H3 quadrangle, that 1969-1974 quadrangle that we looked at. We agreed with staff that the commission, the 1969 commission, had intended to follow a roadway in setting the boundary. We believed that the commission in 1969 simply used an outdated map. It didn't have a current map locating the roadway in its then existent location, and that if it had the current map, since it was following roadways, it would have mapped it along the then existing roadway, which is shown on the right-hand side of the screen, just Mackay of where staff has drawn the district boundary line. So the line was simply in the wrong place. After we had filed the petition to correct the line to follow the then existing road, staff reinterpreted the boundary. And when staff reinterpreted the boundary, and we've put that up on the screen, it put the line in exactly the same location as it had in the prior interpretation. The line did not move. Instead, staff just changed the basis for the interpretation, saying that the boundary line was not actually based on a road, but based on a 300-foot setback from, quote, the line of wave action. And so, although the reasons for the location of the boundary changed from interpretation to interpretation, first following a road and second following 300 feet from the shoreline, the location of the boundary didn't move. And we have them both up on the screen so that the commission can compare the two interpretations that we received. The line is exactly in the same place. We believe, and we believe we'll show today, Chair and Commissioners, that the LEC staff's first reason, the first basis for the interpretation was correct, that the LUC 1969 intended to follow a roadway. They simply got the location of the roadway wrong. We believe, and we believe we'll show today as well, that staff's second basis for the line, the 300 feet from the shoreline basis, is incorrect, that basis is not supported by the evidentiary record. And we believe that that record shows the following: that the maps do not support a 300-foot setback when we look at where the line is, that the text of the Commission's 1969 boundary action does not support a 300-foot setback, and that scaled overlays that we have prepared and that are part of the record as part of that initial set of exhibits do not support a 300-foot setback. We believe instead that the record will show that the Commission intended to follow the general pattern of roadways running along the coast, that a roadway ran through our property when the Commission mapped the conservation district in 1969, and that the boundary should be corrected to follow that roadway. And my final sort of background orientation, I believe, Chair.
Sorry, one moment, Mr. Chip Chase. Commissioner
Yes.
Giovanni.
Yeah, when do we get to the overview? I'm confused. These sound like arguments to me.
Commissioner, I was only, as I said, only trying to orient. Chris, can you jump ahead to the okay. Commissioners, thank you for your patience. It was my next slide. As we will see today, the Commission should interpret the boundary as running along the road that existed in 1969 and that still exists today. Our presentation will proceed in 6 parts. First, we will explain that the Commission did not use 300 feet from the shoreline as the basis for the boundary in 1969. Second, we will review the history of the property, including the agricultural use of the property and the construction of the road that exists on the property today. Third, we will review the LUC maps and apply the Commission's rules and standards in light of the property and its history. Fourth, we will review the public testimony that has been submitted in support of this petition by our neighbors. Fifth, we will hear from the applicant about his current and planned uses on the property and his reasons for bringing this petition. Sixth, and finally, right order, we will close by discussing the Commission's precedent and the standards that applying that precedent to the facts of this matter. And then, of course, as the chair mentioned, will be available for any questions from the Commission. That's the order of our presentation today, Chair, and Santa says thank you.
Okay, so as you well know, Mr. Chip Chase, this is not an evidentiary hearing, right? So I'm a little interested in your idea of bringing in a witness. With that said, we're overdue for a break. I'm going to ask you to bring that slide back up when we reconvene at 10:35, and then I'm going to ask the commissioners to sort of get a first chance at sort of ask you some questions about the organization of your presentation before we proceed. It's 10:25. We're going to recess for 10 minutes till 10:35. Commissioner
Chair.
Wong, there we go.
Okay, hold on, Chair. Something's wrong here. We're muted. Yeah.
No, you're not muted. I can hear you.
Chair, can you hear us?
Yes, still.
Okay, thank you. Just checking.
Okay. It's 10:36. We're back on the record. Mr. Chip Chase, would you put up your talk outline? And I just want to make a space for the commissioners to ask any questions or seek any clarification at this time. Commissioners? Commissioner Wong?
Thank you, Chair. Mr. Chip Chase, I know you were going over the presentation and all this issues. What is the request now? Sorry, I just want to make sure I'm getting it correct, because you're going over all these issues and just want to make sure try to put it in plain English.
I'll do my best, Commissioner. The current boundary line, we believe, is Malka of where the line should be set as corrected. We believe that the line should be interpreted as following the Mackay Road that existed in 1969 when the line was mapped and that ran through the property at that time.
Okay, just want to make sure I got what I was reading in all the exhibits is correct, because yeah, just wanted to make sure I got everything correct, sir. And then
I understand, Commissioner.
Yeah, so I'm just going to ask some questions later in, Chair, so I reserve that right.
Of course.
Thank you.
Commissioners, anything else? If not, so Mr. Chip Chase, I want to be really clear. I want you to have full opportunity to provide all the information that you believe the commission needs in order to rule on this, but it's December 22nd. Not all of us have all our shopping done.
I totally understand, Chair, and I am one of the people who doesn't have their shopping done. I will say that the length of the presentation is in part a reflection of OPSD's comments that we hadn't provided sufficient evidence. So I want to make sure that we walk through what we believe the evidence does show, but I am incredibly sensitive to your time and to everybody's time, and we'll do it as quickly as possible.
Commissioner Giovanni.
Thank you, Chair. Mr. Chip Chase, I'm trying to interpolate from these 6 points really what is the essence of your petition. I don't think that you're before us today just as a matter to correct errors that might have been made by former commissions 60 years ago. What is the motivation of your client for this petition and this declaratory order? And where in these 6 things do we learn of his motivation?
So you will hear directly from Mr. Egan, a member of the petitioner, as to his motivations. I'll summarize them for you, Commissioner. I think it's entirely an appropriate question to ask. There are a couple of things that I'll focus here on. One is that the district regulations are inconsistent between the county and the state land use district boundary. So under the county, his home, Malka of the Road, is within the agricultural district. On the commission's map, that area, as we've outlined, is in the state conservation district. That creates an additional level of regulation with respect to the home and the surrounding property. And he would like to be subject to a single set of regulations, the agricultural district regulations, at least for the main portion of his property. Mackay of the roadway, of course, would remain in conservation. The second is that Mr. Egan wishes to expand the agricultural uses of the property, in particular near the home, to include obtaining income from agricultural activities, which he understands and I believe is correct, is not permitted in the conservation district. Those I'd say would be the two principal motivations, but of course, commissioners, I understand and respect that you may have additional questions for Mr. Egan.
Commissioner Chang.
Thank you. Commissioner Giovanni, have your answers been responded to? Okay. I too am struggling, Mr. Chip Chase. I generally give you extremely great deference as you've always come to us with very credible arguments. There's a few things factually that, and maybe you're going to cover this, but it will help me as I consider your motion. One, when did because I could not find this or else I missed it in the filings. When did your client buy this property?
I don't know offhand, Commissioner, what the answer to that is. It was several years ago, but certainly not before 1969.
Okay, and he bought the property knowing where the lines were drawn, right?
Yes, Commissioner.
Okay. Could you tell me what is his current, it's the HONOIPU HIDEWAY LLC. Could you please explain what is that?
Absolutely. It is a family LLC. Mr. Egan, his wife, and some family members are members of that, as he will explain. They put the property in an LUC or an LLC, I'm sorry, for inheritance and transfer purposes among those family members. He is a software engineer and then also owns a small business on the Big Island, a millwork and cabinetry company.
And this is something that I've not been able to find. What is the difference? Can you quantify exactly what is the difference between the conservation and the ag district that you're asking? What exactly is that? If you've got a map that can show me what is the quantification of the difference you're asking.
Yes, Commissioner, it's 1.8 acres. It was actually the slide right before this that I was going to cover. I'll go back to that slide and we'll take a look at it. And if I just may say, Commissioner, I do appreciate the respect and the attention the commission has always shown, and I don't regard today any differently. We'll put our evidence before the commission, and I understand that it's your obligation to make the decision.
Okay, thank you. Appreciate that. What is he currently using the property for?
So it is currently the portion that includes his home is used as his home. Surrounding that is an area that he uses for agriculture, for family consumption only. And then Malka of that, a portion of the property is in pasture. He owns about 10 cows.
10, okay. And his residence is currently on the area that's zoned conservation. Is that right?
Yes, that's right, Chair. Or that's right, Commissioner.
Okay. And you are using this statute or this administrative procedure rather than doing a district boundary amendment.
That is correct. We believe, as we looked at the history, that the commission intended to utilize this process, that the precedent utilized this process, and that the rules are set up to utilize this process.
Okay. Does he use this property in any way for a vacation rental?
No, Commissioner, and as he'll testify, his SMA permit expressly prohibits that use.
All right, and is the SMA line drawn through the ag, or is it at the boundary of the conservation? Do you know?
I don't know offhand. I'm sure we can get that before the end of my presentation.
Okay, that would be helpful.
Very good.
Thank you. Thank you, Mr. Chair. I appreciate Mr. Chip Chase response to my questions, and as that helps me sort of get a better grasp on the facts here. And I'm hoping we're not going to take 2 hours, Mr. Chip Chase, but I appreciate the overview. Thank you.
You're welcome.
Anything further, commissioners, at this time? I'll just clarify, like, so the petitioner is an LLC, correct, Mr. Chip Chase?
Yes, Chair.
So what is the LLC's preferred pronoun?
I would say
Because we keep
is.
saying he.
Oh, the he I reference is Mr. Egan.
Okay,
A
but when
member
we're
of-
referring to the petitioner, we should be using it.
That would be fine, Chair.
Okay, please proceed.
Thank you. Chris, if you could take us back just to give that comparison of what we're asking here. Okay. And scroll up on. Scroll down. Scroll down. So commissioners, we've put up on the screen those two maps that I briefly talked about with Commissioner Chang. The map on the left shows the road on the 1982 USGS map. That road is shown in green. We'll circle the property right there. And you can see that the road as it existed in 1969, was built in 1961, runs through the property. The yellow dashed line represents the current boundary interpretation for the conservation district. And Chris is pointing to that there. And so if you look at the blue line next, the blue line that Chris is pointing to represents the road that existed in 1969 and what we believe to be the correct interpretation of the boundary line. And so Commissioner Chang's question, if you look at the difference between the yellow line and the roadway, which is in green and are also noted with the blue dashes, that is the difference. That is the request here to interpret the line, which we believe is consistent with the commission's intent in 1969, to follow along the roadway rather than the current location. If we
Commissioner
look,
Ohigashi.
Are you referring to an exhibit so I can see it more clearly? All right.
yes, Commissioner.
Yeah, I'm not seeing a blue line.
Yeah.
I'll get the exhibit number for you.
Corrected boundary line for area.
While we're waiting, I'll just explain the map on the right, and we'll get the exhibit number for you for that map as well. The map on the right, again, is the survey of the property. I'll point to the existing interpretation here. That's where the line is currently interpreted to be. As you can see, it's Malka of the roadway and the homes. The roadway that existed in 1969 is shown here.
Are you moving a cursor?
Chris is moving a cursor on another screen.
I'm not seeing it.
Do you not see the line that has come up? We're pointing the arrows directing to the roadway.
I see yellow arrows on the two maps.
That's right, Chair. So on the right-hand map, the Mackay set of arrows point to the roadway that existed in 1969 and that we believe is the correct location of the land use district boundary.
Okay.
I'm sorry, Commissioner Ohigashi, I don't have the exhibit numbers ready right now. Rather than keep you waiting, I'll move on, and as soon as I have them, I'll identify them for you. Which one? That's the map on the left. Commissioner Ohigashi, the exhibit that you're referring to, or that we referred to on the left-hand side, is exhibit 20. You can skip this. All right. As I mentioned in my outline, staff has interpreted the boundary as being set by a metric of 300 feet from the coast. On the left-hand side is the 1964 LUC map on which the 1969 map was based. Roads running from north to south are clearly shown on the map, and we've highlighted them with the blue arrows. Some roads are marked by a solid line. Other roads are labeled Jeep Trail in some locations and marked by dashed lines. This is the portion of the 1969 map south of our property. As you can see, the boundary line is that thick black line. This boundary line follows roads running north to south. We see the same thing on the portion of that 1969 map showing our property, which we've circled down there. And as you can see, the 1969 map follows what the commission believed to be a roadway running just north of our property into our property and then curving Malco. And that's the dashed line that runs along what would be the northern boundary of our property. That roadway previously entered our property on the north side and ran Malco from there. The commission in its 1969 mapping followed the roadway that it believed existed north of our property and then into our property. The commission followed these roadways even when the road was very close to the shoreline. The only exceptions in this portion of the mapping is for areas of historical or cultural significance. And so as we can see in this 1969 map, north of our property, the road, the conservation district line is nearly touching the shoreline because the road ran very far Mackay. Nothing in these maps suggests that the commission in 1969 drew the boundary at any point that was 300 feet from the coast. In many places, the distance is more than 300 feet, and in many places, the distance is less than 300 feet. The commission in 1969 recorded its actions and intent in drawing the conservation district line. This 1969 review recorded the specific actions that the commission took for each region. Where the commission intended to follow a 300-foot setback, and it did so in other portions of Hawaii Island. It said so expressly, and we've put one of those examples up on the screen. The commission explained from Hilo to Kopoho, the shore is rocky with only occasional beaches such as at Hyanna. It is the unique product of recent lava flows running directly into the sea. The conservation district should include the shoreline, and it is recommended that it be extended from the high water mark to a line which is approximately 300 feet Malca of that line. That's the kind of comment that the commission made when it intended to use 300 feet from the shoreline as the basis for the conservation district line. When we look at the text from the review of the portion of the island that includes our property, we don't find any commentary that even suggests a 300-foot setback was used. As you can see on the map, the property is located in the Ahapua'a of Honouipu, which is near what the 1969 review calls the North Point of Hawaii Island. The 1969 review describes the action taken by the commission in drawing the boundaries in this area and the way that we put up on the screen. The commission said the shoreline from Ha'e around North Point to Pololu Valley, is marked by numerous historic artifacts, such as King Kamehameha I's birthplace, and a variety of different conditions, such as rocks, steep poly, and occasional beaches. The land should be recognized by inclusion in the conservation district. As you can see for this area, there's no discussion of a 300-foot setback from the line of wave action. Instead, the commission focused on different physical conditions, such as those.
Mr. Chip Chase.
Yes,
Commissioner
sir.
Chang.
I'm sorry, Mr. Chair. Mr. Chip Chase, how do I express this? You are surmising the LUC's intention, and you're using these excerpts from this report. But do you have the specific, I guess I would call it like a specific record documenting what the commission did for each of these? I mean, these are large swaths of area, Kawai'i to North Point of Pololu. So, but there could have been some unique circumstances that we're not aware of at the time the LUC acted, but your presentation to us is couched in the way that you are essentially saying that this is what the commission intended. If not, they would have said so. My difficulty is taking you are interpreting the LUC's intention back in 1969, where I don't have the direct testimony of the LUC. So you're asking me to accept your interpretation of LUC's intention. That's my difficulty. I will share with you with your presentation and your argument.
Allow me to confess a little bit of confusion. I'm going on or presenting the actual record from the 1969 review. So this is documented in the LUC's 1969 review. And while it didn't review or comment at a parcel level as to its actions and what it did, it commented at a regional level. And at the regional level, it described what it did generally in that region.
And that's exactly my point. It generally described what it did.
If I may.
I'm sorry, go ahead.
Mr. Chip Chase, would you go back to a couple slides to where you showed the road around the parcel?
Yes.
Because I had the same questions as Commissioner Chang. And what I heard you indicate, what I heard you say, I don't have the transcript in front of me, of course, was that what the LUC did was it put the line where it believed the road to be. So I took that as a statement of what you believed the commission's intent was in this particular parcel at that time.
I would say it's two things, Chair. We can actually physically see what the commission did. We
Correct.
see them following the road that they believe existed, right? That much is clear.
You can see where they put the line.
Yes, and we can see the road running along the same area. And so it doesn't take a great leap of faith to say, since the line follows the roadway, as we go north and as we look south, the commission followed a roadway, except those cutouts that you see, such as Kamehameha I's birthplace. That action, the physical thing that we see on the map, is consistent with their description of what they did, intending to follow physical features and to respect areas of recreational, historical, or cultural significance, such as Kamehameha I's birthplace.
But if I may, and you know, I'll let Commissioner Chang go at it, but you expressed you were confused by her statement. So I thought I would jump in. I think if you simply said it's consistent with, I wouldn't have had the same question, but you said this is what the commission intended. And so I was wondering to myself, like, I'm not sure that you know exactly what the commission intended as to this particular parcel. Commissioner Chang, I'll let you continue. Thanks for
No.
indulging my interruption.
Yeah, no. I mean, that is my challenge with this petition, Mr. Chip Chase, is that line that you have, the roadway, they used a very thick marker. So, I mean, I've done surveys, worked with the surveyor. So, but what I'm hearing, the way that you're describing the commission's actions and intentions, you are extrapolating from these descriptions of the report, but we don't know how the commission applied that to each particular parcel. That was generally what they did. They followed it along, but there could have been some nuances that we're not aware of. So I have a real difficult time second guessing other than to rely upon the map. So that's my real challenge, is your whole presentation is based upon you saying that this is what the commission intended, when I don't know if that's what these reports show for this particular parcel. But you are making a conclusory statement that this is what the commission intended.
If I may, Commissioner, I think what I'm doing is piecing together the historical evidence that we have. And I think that's what we do in any historical review, whether it's at the legislative level or at the commission level or at a socio-economic or historical level, right? You piece together the different information that you have and look at the patterns that emerge. And if we look at the patterns that emerge from the Land Use Commission's own words, when they intended to follow 300 feet, they said so. When they intended to follow physical areas, they said so. And they certainly said so over wider geographic areas, but they noted what they did in those areas. And we can see from the record, and we could comb the full couple hundred pages of the 1969 review. I know the chair is cringing when I say that, but we could comb that entire record and we would see that where they meant to do or where they did follow 300 feet, they said so for a region. Where they followed physical boundaries, they said so in a region. And in our region, they said they followed physical boundaries. That statement of their intent, in their own words, not mine, is consistent with the map that they produced.
So I'm going to sort of, at the end of your presentation and after all questions and any further questions for the county or OPSD and any further statements from you, we will accord to, everything you presented the way it deserves. So, you can take Commissioner Chang's statement as her inclinations at this time. And I hope you will proceed with alacrity.
Thank you, Mr. Chair. And, I think Mr. Chip Chase understands my angst here. So I'll let you continue on.
I appreciate that, Chair and Commissioner Chang. I certainly do understand your angst, and I'm trying my best to address it. All right, Chris, can we go forward? Okay. So we've seen the commission's expressed intent for the area that includes our property. And the review generally explains that 4 conditions were used in drawing the conservation district boundary line. And the first condition provides that where a plantation road, farm, access way, or public road exists at the edge of the agricultural uses within reasonable proximity to the shoreline, it was used as the boundary between the agriculture and conservation districts. That's what the commission followed. 2 of the other 4 conditions were also based on physical boundaries. The 4th condition states where no readily identifiable physical boundary, such as any of the above, could be determined, a line 300 feet inland of the line of wave action was used. That's the standard that the commission, or the standards that the commission followed. And this 300-foot line was only invoked when there was no readily identifiable physical boundary. Unlike physical boundaries, it's arbitrary. It's 300 feet from the coast. And so it, in the commission's own list, is its last option where it cannot find those physical features that more easily and better designate shoreline conditions from adjacent agricultural uses and districts. That's what the commission said when it couldn't find those physical features that more readily divide agriculture from conservation. It used this setback. And as I noted above, when the commission applied it within a region, they said they were applying. Yeah, Chris. We know from the commission's own words in its own report that in no place for the review of the quadrangle that includes this property did the commission say or suggest that they were using a 300-foot setback at any point. And when we overlay what 300 feet from the shoreline would look like, it's clear that that's not the line they drew. So we've put up on the commission site our survey showing the current conservation district line labeled there and in yellow, and what a 300-foot setback line would look like if that had been the commission's intent or had been the line that the commission used. As you can see, the conservation district line that they drew does not follow 300 feet from the shoreline. Both lines start, the blue and the current line, from where the old road was located. On the north side of our property, that yellow line is exactly where the old road was located. At that point, the lines diverge, and the blue line, the 300 feet from the shoreline, cuts a jagged dash through the property at an angle toward the shoreline. We know from the commission's map, which is reproduced here, that that's not the line the commission drew. The line cuts a steady, smooth line through the property. When we look at 300 feet from the shoreline more broadly down the coast in both ways, north and south of our property, we can see that that's not the line the commission drew. On the screen is that 1982 USGS map for the larger area. Our property is marked out there in black. We've circled it to make it a little easier to see. The currently interpreted boundary line is shown in yellow. The 300-foot setback is marked by the blue dashed line. As you can see, the 300-foot setback does not align with the currently interpreted boundary on our property, to the north of the property, or to the south of the property. Instead, the currently interpreted line follows what the commission understood at the time to be the location of the roadway. And as you can see from the double solid line that is Mackay of the roadway in places, the road had been realigned before the commission drew its map. And that is the heart of the difference. The commission's maps show that it intended to follow the roadway. It simply didn't know where the roadway was. And if we look toward the south, toward the bottom arrow, we see that 300 feet is considerably Mackay of the current boundary line. That is because the commission was following roadways, physical features, and not 300 feet. If we look all the way down to what Chris has now circled, that area actually did not have a roadway running through it at the time. Instead, there's a roadway just south of that area, just as the roadway, the old road, stopped just inside our property and turned Malka. All the commission did is connect those 2 points. But as you can see from the blue line, the commission did not connect them using 300 feet. If it did, the line would have been, in most places, considerably Malka of where it was. Instead, the commission connected these 2, then, as the commission believed, existing roadways using clean, smooth lines. Go ahead, Chris. This map shows the current boundary line again in yellow. It also shows the roads that the commission believed existed at the time in blue. So that blue dashed line and that yellow line where the commission actually drew the boundary are coextensive, except at the top around to the north, Kamehameha I's birthplace. And then when the line turns, the roadway, I should say, turns Malka into our property, the commission simply continued that line, the yellow line, from the end point of what it believed to be the location of the roadway south and connected it with another roadway that existed at the time to the south of the property. And so coming back to Commissioner Chang's questions, we don't have to guess at what the commission intended to do. We can see that it followed what it believed to be the roadway that existed at the time all the way into our property. So this record of the commission's actions shows that the current boundary line follows the roads where they are mapped. The review that the commission conducted and prepared expressly states every example that we can find where it intended to use 300 feet from the coastline as the metric. Nothing in the description of the action for our region indicates that the commission used 300 feet for any portion of the region. We know from the commission's own words in its report that it favored physical conditions and that a 300-foot setback was not the favored condition. And we know that a 300-foot setback, when scaled through our property or over the broader area to the north and the south, does not follow 300 feet from the shoreline. So if the commission did not use a 300-foot setback as its metric, what metric did it use? We believe that the evidence shows that the commission followed a road where a road was mapped within a reasonable proximity of the shoreline. And that is consistent with the commission's order of conditions and its preference for mapping the line between conservation and agriculture. As we can see from this map, if you look to the north, the commission follows the roadway. If you look to the south, the commission follows the roadway. In between, the commission simply connects those 2 points following the general contour of the shoreline. The commission connected these 2 roadways, even where the line closely abutted the shoreline. We see this on the 1969 map. And if we look at all of the mapping for the entire quadrangle, this is the consistent pattern. Going back to the commission standards, the boundary followed a roadway at the edge of an agricultural use within a reasonable proximity to the shoreline. That's the commission's first condition. when the roadway ended or turned Malka, as it did at the north portion of our property, the commission simply continued the approximate line of the roadway. As we can see from the mapping, the line at the north portion of our property, the boundary line at the north portion of property, is exactly where the commission believed the roadway to be. Go ahead, Chris. On the screen is an aerial of the Mahukona area in 1954. Even from this vantage, we can see the property that we have had outlined with the TMK number in black. Zoomed in, we can see the property as it existed in 1954. The records for this property indicate that it was in agricultural use. These two documents, and they're exhibits 33 and 34, show the property in the land, show that the property in the land in its vicinity was being used for ag in 1959. Exhibit 34 is a Coast Guard speed letter discussing the purchase of the land in which its station was to be located. The letter explains that authority had been granted to cut pathways in sugarcane if necessary to mark out the boundaries for the Coast Guard station property. Exhibit 33 is an office memorandum regarding land valuations based on tax assessments for this area dated March 17th, 1959. Paragraph 2 discusses the land valuation for this parcel, the parcel that we're discussing, which was owned by Bishop Estate at the time and where the Coast Guard station was eventually located. With respect to this very parcel, the author of this memorandum notes our land seems to fall within the medium pasture land category. Those records, the Coast Guard's own internal records of the property, are consistent with the 1969 review. That review confirmed that the property was used for pasture land at the time the boundary lines were drawn. A map of Hawaii Island is included in the 1969 review, and it records the ag uses occurring at the time. As shown on this screen, the property is located in North Kohala, and the lands in dark green are labeled cultivated lands. Lands in lighter green are labeled lands presently used for grazing. Our surveyor has marked the approximate location of the property on the right. As you can see, the property falls in the lighter green area. This is what the Coast Guard's own internal memo characterized as medium grazing lands, and the 1969 review records show is being actively used for grazing. The recordation of ag uses on the parcel and throughout the area supports the conclusion that the commission would have applied the same rule based on ag uses throughout the area. And that's the rule that we've discussed, that you follow a roadway where a roadway exists. And that's what coming back to Commissioner Chang's points, that's what the LUC tells us was its intent, to follow roads where they existed at the edge of the agricultural use within reasonable proximity to the shoreline. So based on these records, we know that the area was used for ag, and we know that a road existed on the property both before 1961 and after 1961. The critical point is the location of the road. And we know from the historical record that prior to 1969, when the LUC first mapped the conservation district line, that the road moved. Prior to 1961, there was a dirt road in the area that dirt road rounded out toward the shoreline and turned Malka at a 90-degree angle just inside the boundary of the property. The road ran along the northern boundary of the property as shown in the photo, and we've outlined that right there. That's the location of the road prior to 1961, and you can see it entering the property. If we think back to the earlier maps, we know that that line is coextensive with the land use district boundary that the commission drew. This is the old road that was mapped on the 1957 USGS. Chris, would you? If we look up there toward the north, the top of the map, we see where our property is, and we see again that road. Zoomed in, we can more clearly see the old road that curved toward the shoreline before turning Malka. And again, that road entered our property. So then shown on the screen is a comparison of the 1954 aerial and the 1957 USGS map. As you can see, the curvatures of the roadway entering our property match on both maps and are consistent with the conservation district line. While that roadway was accurately mapped in 1957, it no longer reflected the actual physical conditions when the map was ultimately adopted by the commission in 1964, or when the conservation district line was drawn in 1969. Between 1957 and 1964, a new road was built to the north of the property and through the property. Okay. On the left-hand side is an aerial of the property in 1954. As you can see, the road does not curve along the property or hug the shoreline. On the right is an aerial photograph of the property from 1965. And as you can clearly see in that photograph, the road cuts through the property and hugs the shoreline. This road was built in 1961. We put up on the screen a newspaper article that documents when the road was constructed. As the article explains, this new road took the place of the old road that ran not only through our property, but to the north, and that was mapped on the 1957 USGS. We have up on the screen actual Coast Guard photographs of this road that was built in 1961. And they depict it here as a newly graded road. On the left, we have the 1964 map with that 90-degree turn at the edge of our property. On the right, we have the 1965 aerial. And you can see that the road has been moved, extended south, changed to the north as well, and now has a rounded turn. Our property is now completely within this rounded area. So the result is that while the commission believed it was following roadways when it drew its maps, the roadway was not in the right location through our property or to the north of our property. And the result is simply a mistake that places buildings and roadways that existed at the time within the conservation district. On the right is the 1982 USGS map that does correctly depict the roadway. And this petition simply asks the commission to interpret the location of the district boundary line along the actual location of the roadway that existed in 1969. This is the road then, and this is the road today. It's the same exact road in the same location through time. As we know that the commission intended to follow roadways and that it did so to the north of our property and into our property as far as it believed the road went, we can conclude that if the commission had a correct map of the property, it would have done what it said it was doing and what its mapping indicates it was doing, and that's follow the roadway. On the right is a corrected survey of our property. On our property, the interpretation is represented by the black dashed line that runs along the contour of the roadway. That we believe is the correct interpretation of the conservation district boundary. It results in a small but important correction, 1.813 acres, Malka of the roadway, as being interpreted as falling within the agricultural district. Although not at issue in this petition because it only concerns the property, we wanted to show the commission the effect of the interpretation on other properties in the area. And as you can see, to the south of our property, the correct interpretation meets up with the current interpretation at the southern boundary. The current interpretation is in dashed yellow. The correct interpretation, we believe, following the road that existed at the time, is shown in green. They meet up at the southern portion of the property. To the north of our property, we can see that the commission believed it was following the roadway that existed at the time. And we see that up toward the top third of the map, where the road that did exist and does exist is entirely coextensive with the conservation district boundary. The problem is just south of that, approximately where the sea is, where the roadway previously existed exactly where the commission mapped it. But before the commission drew its line, had been moved Malka, and its alignment changed. Even if other petitioners were to come in and seek clarification, the changes are not significant. It's simply following the road that existed at the time, only in those locations where the roadway, where the commission in 1969 simply didn't have current information about the physical conditions in those properties. To the north of our property is a DHHL parcel. That is the bulk of the area to the north of our property. DHHL has been advised of this and has not expressed any opposition to the petition. Go ahead, Chris. I'd like to, at this point, allow the petitioner's member to speak with the commission, and I believe that will enable the commission to ask questions that might be best put to the applicant rather than the attorney. Chair, I believe you're on mute.
Why don't you stop screen sharing?
Very good.
I'm sorry, and I apologize if this is something I missed in the written materials. So DHHL is a client of mine. I did not know until this moment that they were the adjacent boundary member. I've never discussed this matter with them, but I just want to disclose that and give you the opportunity to object to my continued participation in this hearing.
No objection, Chair.
Okay. Commissioners, we're fine with hearing from Mr. Egan. Okay. Let me swear him in. He has to be admitted, right? There, his hand is up. I'm going to promote you to be a panelist. You can now enable your audio and video.
Thank
Okay.
you.
So I'm going to swear you in because our quasi-judicial proceedings in general, we do this. You swear affirm the testimony you're about to give us the truth.
Yes, I do.
Okay. Now, Cal, had you fashioned this as having some direct examination of him?
Very brief, direct, Chair.
Please proceed.
Thank you. Mr. Egan, would you please just introduce yourself to the commission?
Sure. My name is Nathan Egan, and I just wanted to say thank you all for taking the time to hear this petition and speak with me today.
And Mr. Egan, what kind of work do you do?
Yeah, I'm a software developer, and then I also am a part owner of a small business here on the Big Island that we make cabinets and millwork and that sort of thing.
And are you a member of the petitioner?
Yes, I'm a member of the LLC that owns the property.
Are there other members?
Yes, so my wife is another member, and then some of our other family also are members.
And why is your ownership structured as an LLC?
So it makes basically shared ownership easier, as well as inheritance. You know, some of them are older, they're going to be, you know, doing estate planning, passing it on to their children. So it's kind of a family event.
And as we've discussed today, the property that we've looked at is in both the agriculture and the conservation districts. Do you know what the county zoning for the property is?
It's A20 zoning.
And the current boundary interpretation puts the conservation district line Malca of your home and an area that I know you use for some agriculture. Could you describe for us the impact that that designation has and why you're asking the commission to interpret the boundary as running along the Coast Guard Road?
Sure. Yeah, so, you know, right now, the current boundary interpretation, it has the conservation line kind of up the hill from our backyard. And, you know, as I've kind of lived and learned more about all of the rules and regulations for conservation zoned property, having, you know, the part of that property I actually live in, my yard and my house incorrectly in the conservation zone has created a lot of problems and just extra work and processes. You know, it makes it hard to do things as simple as landscaping or planting trees, you know, installing an irrigation system, trying to get solar panels, you know, to reduce my energy costs, things like repaving my driveway. All those things, you know, they can be done in conservation, but they take, you know, a significant amount of extra procedure. Some of them take years to go through the process, require, you know, lots of permits and approvals. And that's in addition to just normal things that we all do with our county government, getting building permits and that sort of thing. So, you know, the way that it's regulated right now, my wife and I were not supposed to dig a hole with a shovel, disturb the soil, cut a branch over 1 inch in diameter without sending a letter to the OCCL in the mail and then waiting for, you know, up to 30 business days for them to send us a letter back approving our action. And they're all really nice people. You know, I know the OCCL people, I've worked with them. It's not about that being, you know, good or bad, but it's just a very burdensome process for just living and using my home. And I think that correcting this issue would really simplify our lives.
Would you describe for us briefly just some of the ag uses that you currently engage in on the property?
Yeah, we have a few things. So, you know, our immediate yard area is planted with trees and fruits that have been, they were all kind of put in when the Coast Guard was here for the people that live there. So we've got things like avocados, bananas, coconuts, mangoes. And then in the upper portion of the property that's more exposed and not as protected from the wind, it's the lower area with the trees is more like a kind of a gully. The upper area is more like a pasture, and that area we have cows in for part of the year for fire control, you know, and just managing that pasture land a bit better than letting it go wild.
And with respect to the produce that you grow, do you sell any of that commercially currently?
No, right now, because all of our produce is grown in conservation zone land, we're not allowed to sell that product. I mean, you can't have any commercial activity originating from conservation zoned. The subzone that we're in prohibits that without, I could go and get a permit, I think maybe to do it, but again, that's a board level permit. It takes a year and several public hearings just to be able to sell an avocado. So it's a bit burdensome.
And if that land were in agriculture, what would be your intent with respect to your growing operations?
Yeah, there's a lot more land available in that area, 1.8 acres of sort of prime land that's protected and hopefully would be irrigated. We can grow a lot more trees. My wife and I, we both come from agricultural backgrounds. Our parents all grew up on farms, ranching, and we both moved to, a rural place with land to grow because that's one of our main reasons to be here. So, we'd like to plant more trees. There's a wonderful farmers market up in our town, Hawai'i, and we'd like to be able to sell our produce there and really share that with the community.
And if the boundary line were corrected as we've proposed, do you have any plans to develop the property?
That's a good question. I don't. The property is already developed. The property was developed in 1961. The house I live in is from 1961. Nothing about the property has changed. And I think it's really important, I've learned a lot about all these rules in going through this process that, with the shoreline portion, the Mackay portion of the property remaining in conservation, there's no potential land use action that could be done by me or anyone ever that wouldn't go through the most rigorous form of regulation from the state of Hawaii, right? You can't subdivide it, can't build anything, you can't get a permit to do anything because of that conservation presence. And I think the other piece is, and this was asked by one of the commissioners, I believe Commissioner Chang, the entire property, shoreline to top of it is in the special management area and is already regulated through the special management area permitting process.
And Nathan, for the portion of the property that you've described as being better for growing produce and other forms of agriculture, do you have an understanding of how that property, that area was used when the Coast Guard owned it and had it stationed there?
Yeah, I had an opportunity to speak with the former facility manager for the Coast Guard who operated the property before it was shut down. His name was Arthur Greiner. He unfortunately has passed away during this COVID pandemic, but he shared with me how they had planted the entire property with fruit for each of the homes and the people that lived there to give them, extra basically sources of food, because especially back in 1960, this was extremely remote. There was very little choice for like fresh goods and produce. And so they did a lot to make it really hospitable for them. And that area that they chose to situate the homes is, as I said, it's like sunken down and protected, because if any of you have ever been to Kohala, or if you, look around the area, there's a gigantic wind farm. It's a very windy place. And so it's quite hard to grow in the majority of this area, unless you have some sort of natural benefit.
Mr. Chip Chase, you said brief. How much longer do you have? We're time ready for a break.
I just had two more questions, Chair.
Proceed.
Thank you. The first was just in response to a question that Commissioner Chang had asked, and I thought better to hear from the applicant. But Mr. Egan, do you intend to operate an STVR on your property?
No, we don't. The property is the place that we live, and it's our normal life here. And then, the other thing is that the special management area permit specifically for our property prevents any STVR operations as a condition of it. And those permits are revocable if anyone was to ever violate that precedent.
My last question, Nathan, did you have an opportunity to talk to your neighbors about your petition and the request to correct the boundary line?
Yeah, you know, it's not a requirement of this process, but I wanted to tell all of them what's going on. So I spoke to each of my adjacent landowners. You know, all of them support the petition. Several of them sent in supportive comments as public testimony, took the effort to do that. And then I also spoke to DHHL, who's my adjacent neighbor. You know, they're obviously impacted by this same error. They and I have a really good working relationship. We support each other in all sorts of ways on an ongoing basis and have for years. And so, you know, I think across the board, there's strong support and no, you know, negative feedback from any of them.
Thank you, Nathan. Chair, I have no further questions. I appreciate the opportunity.
Okay, it is 11:41. I'm going to take a 10-minute break, reconvene at 11:51 for questions for this witness, and then we'll assess our proceedings. 10-minute break. Let's go back on the record. I'm going to recognize Commissioner Chang, followed by Commissioner Giovanni.
Giovanni doesn't have his hand up.
Excuse me. Oh, Higashi, Kalamai.
All right.
Commissioner Chang.
Thank you, Mr. Chair. Oh, good morning, Mr. Egan. Thank you for being here this morning with us. I have several questions I'd like to ask you. The first one is, what does, how do you pronounce the name of your LLC?
It's HONOIPU HIDEWAY.
Can you tell me what does that mean?
Sure, yeah. So it's a name that we came up with as a family, and you know, we wanted something historical. This is a really important area, important piece of land. Honoipu is the name of the ahuapa that our property is located on, and so we like that. You know, it's also the ipu is the gourd, right? And it would be like something you'd bring to like a family gathering with food in it, and so it's like a place that we all gather together. So we kind of thought that was a good tie-in. And then Hideaway, you know, if you look at the map of this, it's basically at the end of the island. You know, there's thousands of acres of land around it. You really feel like you go down this long road and you're all by yourself. So it feels like you're hidden away from, you know, kind of the ends of the earth. So we thought it was fitting.
Okay, sorry. And I'm sure you meant ahupua'a.
I'm sorry, yes.
No, that's okay. We all have a hard time with that word as well.
It's a hard one, yeah.
Yeah, I appreciate the explanation for the name. In Hawaiian, you're right. Hawaiians give names, and it's very important because a name becomes a place. So I appreciate you explaining to me your intention. Could you tell me, when did you buy the property?
Sure. I bought it in March of 2018.
2018. And when you bought the property, did you know that that a portion of it was in conservation land?
Yes.
Okay. Let me just, your counsel has described the intention of the LUC Commission when they drew the boundary line. And essentially, he's indicated that it was the intent of the commission to follow the roadway. And let me ask you this. Do you think another plausible explanation could be that because the Coast Guard had changed the location of the roadway, the uncertainty of the placement of the roadway, that the roadway was no longer a monument that should be followed because who knows, the Coast Guard could change it again. And that based upon the intention of conservation district lands, 205 2-E to preserve scenic and historic areas, preserve water resources. That do you think another plausible interpretation of the commission's intent when they drew that line, that it wasn't a mistake, it was intentional to draw the line where it did?
It's a good question. I've considered that myself, I try to be objective about it.
Mhm.
I think that, it looks pretty clear to me that somebody that's in the business of mapping and providing accurate records wouldn't certify a map that had an obvious like missing or mistake on it. The base that's depicted truly did not exist in any way. In fact, in 1959, they demolished the entire base that's depicted on the Land Use Commission map. It was actually graded and taken down to the ground. And the base was enlarged from 20 acres, the size that you see on the Land Use Commission map, to 100 acres. So it was made 5 times larger at that time. And so I think that although they may have wanted to do or specify one intention or another, again, I maybe it's not my place to say what their intention was, but I don't think someone who's a surveyor or a mapper would purposefully record an incorrect map that doesn't reflect the actual like structures, roads, and land.
And I guess you are assuming that it's intentionally incorrect. And I understand the argument, but I've just proposed an alternative interpretation that given that the roadway had been changed recently, that the Land Use Commission, rather than using that as a monument, because it was not necessarily a fixed roadway anymore, it had been newly put in, that the line that they drew for the conservation land, in particular on the property that you currently own, was intentionally drawn at that location. Wouldn't you agree that that's a possible interpretation of the LUC's intention?
I don't see any other evidence where they've done similar things. I looked at the conservation boundaries for the entire state of Hawaii in my own research, and I can't find any evidence where similar types of mapping issues have been resolved in the way that you're describing them. But I mean, ultimately, I think that's part of what you as commissioners are here to decide. So I really feel like my opinion is minor in the grand scheme of it.
I'm very impressed that you've looked at all of the conservation district. I was a former deputy attorney general with DLNR advising conservation, advising OCCL. I don't even know if I looked at all of the conservation maps. So I applaud you. But nonetheless, I think my point is that I think that we are all surmising what's the intention of the Land Use Commission. And I think it is fair to conclude that there might have been other intentions other than to say that the line was drawn intentionally along the roadway. And I guess that's my only point. Let me move on from that. My other question is, you said you went and talked to, well, let me ask you, did you talk to OCCL regarding the regulations that were applicable to conservation lands?
Yes, they visited the property with me, and then we've also talked on a number of occasions.
Okay. So one, you knew you bought conservation lands, you spoke to OCCL regarding the regulations. At what point in time did you decide to pursue this boundary interpretation? Because you bought the land in 2018. When did you talk to OCCL?
Also in 2018. They were the organization that told me that they weren't in the boundary business and directed me to the Land Use Commission to seek a boundary interpretation. So,
did they ask you to seek a boundary interpretation or a boundary amendment?
A boundary interpretation.
Okay. And you've chosen to do a boundary interpretation versus a boundary amendment. Is that correct?
That's right.
And
Yep,
can I ask
that's
you
correct.
why? Why did you choose a boundary interpretation rather than the amendment?
Yeah, that's a good question. So there's a couple of reasons for it. When I initially started this process, I was working on my own, working with the Land Use Commission staff, kind of learning how all this pretty complicated process works, to be completely honest. At that time, a staff planner told me that based on the information that I had shared with them, that I should pursue a boundary interpretation. And if there was a problem with it, to seek a declaratory order.
Okay.
You know, the problem with the amendment is that it's like, I'm a normal person, and an amendment takes, it looks like several years at best to be carried out. You have to do an environmental impact statement that costs $100,000. Like, this has already been really expensive and time consuming. And I think that it would be burdensome.
No, I appreciate that. I mean, you do have, you know, your counsel has been before us many times. He's extremely competent. So you do appear to have the resources, but I do also, you know, I appreciate that you also spoke to the adjoining landowners. But if there may be an interpretation based upon what you're arguing or you're purporting, may have broad implications just beyond your adjoining landowners. There may be other properties all along both the state of Hawaii as well as the island of Hawaii, where people may come in with the similar arguments that the line is there's a mistake. Have you spoken to anybody else besides just your adjoining landowners?
I have not talked to anybody else. I did, you know, just try to see if I could find another evidence of that. And at least in my review, I didn't. I mean, I think one aspect of this is that the military base, when it was originally constructed, was top secret. And so there was very little like public communication of what was happening about it until 1961, when it was like opened up and put in the newspaper and whatnot. But I don't think that, you know, people necessarily would have this same situation where a federal agency built the roads of their own accord, right? Like, usually any other action would have permits and records and activities that would have been regulated by the state and county in which they occurred. This one was basically a unilateral federal action that kind of like went outside the bounds of the normal state processes.
Yeah, no, that's an excellent point. And that may have been a consideration by the Land Use Commission, knowing that it had previously been used by the military. And so things could have changed. But, you know, I've appreciated your responses. And Mr. Chair, I think at this point in time, I don't have any other further questions.
Thank you, Commissioner Chang.
Thank you.
Commissioner Higashi.
Mr. Egan, is that how you pronounce it?
It's Egan, but that's fine. No problem.
Egan, Mr. Egan. I'm sorry. I was looking at your exhibit number 19. I'm not sure if you have it in front or if you know about it or.
I can grab it while we're speaking, definitely.
And I was just looking that your proposal appears to place the new boundary that you're requesting, or the corrected boundary, on the road fronting two structures on the property. And there are two structures on the property. Are those residences on the property?
They are, yep.
And one is outside the property boundary line, according to Exhibit 19. Is that a residence or people living there?
Yeah, it's a residence. And the boundary issue is something that was created when the federal government owned both parcels, and they basically developed it as one large facility. And they didn't really pay very close attention to the locations of lot lines. So DHHL and myself have basically a boundary agreement about the issue, like an easement, to address it.
So
And
you,
that's,
so DHHL has, you have an easement from DHHL to occupy that structure.
yeah, it has a different name. I'm trying to think of the exact legal document, but that's an example of like, you know, like we provide them an access easement to their property, which is landlocked, and they address this lot line issue, which is again, kind of like this problem. It's nobody living's fault. It happened 60 years ago, but it's an issue nonetheless.
Could you tell me who's living in the two residences?
My wife and I live in one, and the other one is used by our family when they visit. Some of them come for the winter. If it isn't COVID, it's a bit more often.
Is the one outside the boundary line your residence, or is that the one that is being used by your family?
The one that is outside the boundary line is used by the rest of my family. We live closest to the road to kind of keep an eye on things.
And I'm not familiar with an LLC, but is that, are you the managing member, or are you, is that your title?
I mean, we all technically are owner managers, so there's no subsidiary level of members.
Now, your proposal would place you, these two structures, outside of the conservation zone. Is that right?
That is correct.
However, the portion that exists outside of your property line would be subject to conservation district requirements. Is that right?
I don't know the technical answer to that. I mean, I'm not sure if you were to make this correction, if you would or would not also correct the basically related issue on the DHHL parcel. It's not part of this request.
No,
Of the record.
your declaratory ruling, your declaratory request is only for your parcel.
That's my assumption, yeah.
So it does not address that problem. Is that right?
Yeah, it's a complicated property.
When I started out, when the Office of Planning gave their opening or their statement, I asked them about their Exhibit 4. And according to their Exhibit 4, they placed a 1982 paved road based on, I guess, their GIS survey above the existing residences. And if we were to follow Office of Planning, which is the state arm of planning, and their GIS, then we could relatively assume that the residences would remain within the conservation district zone. Is that right?
I disagree on that one. I think if you look at that document, you'll see that it says it's not to be used for boundary interpretations down in the corner of it, because the GIS data isn't accurate, and it's actually when you go ahead.
I see something signed by the executive officer on 10/26/2020 of the Land Use Commission. So the boundary.
That's not mine.
Named and delineated is hereby certified as the actual land use district boundary. So my question is that given the two different maps, we seem to have a fuzzy type of record figuring out where exactly the boundary line is on that you're requesting to be moved. Is there any historical record of the 1982 paved road being above your home?
There's not. There's an aerial photograph that we've shared with you from 1965, produced by the U.S. Department of Agriculture, that shows the road in its current location in front of my home.
It's always been surveys of the 1982 paved road done, or the 1982. I'm trying to be correct.
Sorry, I need to just instruct the witness to not interrupt, because it makes the transcription from this recording nearly impossible.
Yeah, I'm sorry. Maybe I'm proceeding questions too quickly too. I'm going to try and I'm just trying to, it's the 1982 topographical map that they use this line to say the 1982 paved road. Are you aware, as the owner and person who done research on it, and I guess as an architect, are you aware of any surveys done of that particular road?
That's a good question. So the road is not from 1982. That
No,
map,
I'm referring to the map.
okay.
I think we agree that the road was created before 1961.
Right, I agree. So the Office of Planning's exhibit is a base map that my surveyors created and was certified by the boundary interpretation process that the Land Use Commission uses. And then the Office of Planning used GIS data and overlaid that on top of our map. The GIS data is not used by the Land Use Commission for its own boundary interpretations, from my understanding. And it's not accurate within a reasonable, like for the scale that we're looking at, it's not an accurate representation of location. The road itself is very clearly in the aerial photographs that predate that map in the same location that it's in current aerial photographs. So I do not believe, and none of the surveys that we have or aerial evidence show that it was ever behind the homes. The homes obviously have not moved.
When were the homes built?
1961.
So there could have been a road prior to 1961 that was modified in 1961 after to include, to be moved further down for the purpose by the Navy. Is that right? I mean, for all we know is that this paved road in this map was moved lower prior to 1961 because they wanted to develop those two particular properties.
I think the evidence that we've provided shows that they expanded the base and put the road from going around the base through the middle of the base. In 1960 and 61, they completed construction on June 2nd. And the road, as it's depicted in the aerial photographs from 1965, is an accurate representation of that. And those same aerial photos from present day match the 1965 aerial photos. So I think the location of the road as certified in the shoreline survey, the boundary interpretations, is very accurate. And that is equivalent, or is the road just depicted as the 1982 USGS road is shown on that map. Unfortunately, the OP map is basically inaccurate and wasn't done by a surveyor using data that has a margin of error or specificity that's much too inaccurate to be like used for this type of determination.
And I would presume that that is your argument and not your testimony. Because are you a surveyor?
I'm not a surveyor, but the maps that we have provided.
Do you have expertise in determining whether or not the GIS map is accurate or not?
I am not a surveyor, and I do not have expertise in determining if their map is accurate.
Okay, so that's all the questions I have.
Commissioners, further questions for Mr. Egan? Commissioner Giovanni, followed by Commissioner Cabral.
Thank you, Chair. Thank you, Mr. Egan. I'd like to go back and follow on to some of Commissioner Chang's questions and answers that you provided. So when you purchased the land in the property in 2018, you had you acknowledged that you understood that part of that land was zoned in conservation. That's correct?
That's correct.
What did that mean to you at the time?
Well, at the initial time, I didn't have a full understanding of what all those rules and regulations were. And I tried to work, collaboratively and carefully with both OCCL as well as Hawaii County and all sorts of other agencies to make sure that I did understand them and followed those rules and regulations.
So when you worked, was that before or after you purchased the land?
Well, it actually started before the transaction closed, so that part of it, I realized I would need to do special management area permitting and potentially the conservation district use CUDL permits. So I started learning about both of those processes before the purchase closed and after the purchase closed continued.
So it would have been possible for you to not close on the property based on the learnings that you developed in the process at that time. Is that correct?
I think that's true, but I like the property.
So strategically, you strike me as a person with both tactical and strategic thinking and critical thinking. Was it your intention at the time to pursue changes to either through a district boundary amendment or some other process now, this interpretation process, to rectify this for some reason? Did you see it as a problem and you had to get corrected? I mean, what motivated you at the time, at that point in time, and what's your motivation today?
Yeah, it's a good question, Commissioner. So I didn't know that there was a mapping error when I bought it. It wasn't apparent to me. I mean, to be quite frank, it takes a lot of staring at these maps. I mean, I live here and I had to stare at it for a long time to even get an inkling that there was something wrong. It's not blindingly apparent unless you're a surveyor. So at first, I didn't realize that there was an issue. I think what has really driven us to try to correct this error is that I mean, I don't know if any of you live in conservation zone property, but if you are trying to be a good person and follow the rules, they're quite burdensome. And the more duration that we've experienced that, the more I think that it's just become clear that we'd like to have a simplified life. I mean, for us and, someday for the people in our family that inherit it from us and live here too, we just don't want them to be having to kind of it's almost like having two masters. There's always this sort of convoluted process of who has jurisdiction, who's going to approve your request, shuffling paperwork back and forth. It's a little bit complicated.
But all of that is necessitated because of your intent to make changes. Is that not correct? And you're trying to make changes on conservation land, and the purpose of conservation land is to conserve it, not make change. So it goes with it kind of goes with the bargain, if you will. You buy conservation land. You have to deal with the bureaucracy, and I'll put a word in from my point of view. It might be viewed as by some landowners as even a hardship to try to exist on conservation land. But isn't that something that you realized at the time that you purchased it, or realized it at a point in time where you were learning about it and still could extract yourself from the transaction?
I don't think that I really realized the full implications until after we closed on the property, because we weren't able to really proceed very far with the process until we actually had ownership of the property. Like they wouldn't really engage with us or allow us to submit any kind of requests or permits until we owned or had title to it, right? So the most I could do was basically read and learn, but not really engage in a significant way to find out what the limitations were going to be specifically for this property. But I hear where you're coming from. And I think that, you know, it's definitely something that's easier to see in hindsight than in the moment.
Fair enough. So in the 3 years that you've owned the property and have had to deal with the regulations involving the conservation land and submitting requests and inquiries about it, have you ever gotten a refusal or turned down on any request?
Well, I would say that generally when faced with the process that we would have to do, we haven't proceeded with any of the more complicated things that I'd like to do. For example, getting solar panels requires a department level permit, a D level permit with a public hearing and a 12-month lead time. And I can't find a solar installer who will even start the process of doing that on my behalf, right? So I'm basically blocked from, I can't install a solar system. I need someone to do it for me, and no one will deal with the state to carry out that process. So those are the kinds of things that are.
Have you considered installing a ground-mounted solar system on the agricultural land instead of putting it on the conservation land that you own?
I have considered that. The problem for me is that I don't particularly want to look at a ground mount solar system as my view, and I have a big roof with nothing on it. It seems like the logical place to put a solar system, but it's a point. You know, there's always lots of ways to solve a problem.
Thank you. I don't have any further questions. Thank you, Chair.
Thank you, Commissioner Giovanni. Commissioner Cabral. Commissioner Cabral, if you're trying to talk, you're muted. Commissioner Cabral? No? Commissioner Wong, you're winding a flag.
Yes, I got it from staff so you can see me, Chair. Thank you, Chair. I have several questions regarding your property, sir.
Okay.
So I'm going back to, again, you know, your property before 2018, was it owned by only one person, or prior to that someone else bought it, or do you know the history of the property?
Yes, I do, Commissioner. I bought the property from the Parker Ranch Land Trust. They were the original owners of the property before the federal government owned it. They had a reversal clause in the deed, and so when the federal government stopped using the property, it was returned to them in the year 2000. They held it from the year 2000 until we purchased it in 2018.
So and before that, as you said, before Parker Ranch, the federal government owned it a little while. That's correct? Just want to make sure I'm following the.
Sorry, my headset is just running out of batteries. One moment.
Okay.
Well, I think you can still hear me. Is that correct?
Yes.
Okay. So the federal government owned it from 1959 until the year 2000, roughly.
Okay. So I guess I got to go to Parker Ranch then, because do you have any evidence on the record that the owner, which is Parker Ranch, objected to the LUC's boundary, you know, to the boundary map about the conservation boundary?
In their ownership until 1959, or their ownership from the year 2000 and later?
Yeah, well, so the assumption is they owned it, they owned the property before the federal government. I'm assuming that's the case, right?
They did.
So, when the LUC or the state did this conservation boundary map, which we're talking about right now,
Mhm.
do you know if they had any problems or was there anything on your record that you know of that said, hey, you know what? I don't like where you put in the line, so change it.
Well, when the conservation line was created, the federal government owned the property, so I don't think Parker Ranch would have been aware of it. But I don't know beyond that.
Okay. So I just want to make sure I understand because, Parker Ranch is a big landowner. And I would assume that when you bought the property from Parker Ranch, you kind of understood, the escrow or whoever did the background checks it. Hey, there is a conservation land. There was issues on this, but I guess they didn't say anything about that issue, right?
They disclosed that it was partially in conservation, and they disclosed that they discovered the lot line issue that we discussed earlier with one of the other commissioners when they had a survey of the property done. They didn't resolve the issue with DHHL. They didn't ever seek to do so. And so it wasn't until we purchased it that issue was resolved.
2018, approximately.
Yes.
Yeah. So the other questions I have is, we're going through a declaratory ruling. I understand that we're dealing about the land, the property, the changes of what we want to do on it. So how come you didn't come and do a DBA instead?
Is that the district boundary amendment, Commissioner? So the reason that I didn't do a DBA is that when I spoke to the Land Use Commission staff initially in this process, and we determined that there was this sort of inconsistency in question, one of the staff planners told me that this was the process that I should follow. And I started down that process on my own and felt like it was pretty difficult and confusing to do a declaratory order. And at that point, I retained my counsel from Cal and team to help with that process because I didn't know if I would be able to complete it on my own.
Yeah, Cal has been in front of us a lot of times, so he knows our process. Not taking any position at this point in time because I want to hear everything. Let's say we deny this, would you come back for a DBA?
I don't know definitively what I would do yet. I mean, it would be a significant burden on me to do an environmental impact statement. I mean, I honestly, like I think I mentioned, I mean, I've spent exponentially more money on this than I ever dreamed that I would have to. And I mean, that's like the price of a college education to do a district boundary amendment for a child. So I would have to evaluate it. I don't know.
Okay, thank you. Thank you, sir. Chair, I reserve right to talk to council after you finish this presentation.
Thank you, Commissioner Wong. Commissioner Cabral.
My apologies. I think the battery in my mouse died at that a little bit ago. It's the weather over here. Okay. Yes, thank you very much for meeting with us. And I can only imagine how expensive this whole process is and how irritating and cumbersome it is. And we understand conservation districts are very protective, which of course is their intent. My questions are, I think, a practical matter. Okay, so your house, because it's in this low-lying area where it's best protected from the winds, and I'm on the Big Island, so I've been in that area at least, if not on that roadway in the past, and used to fish a lot up there a lot. You're in conservation. Approximately how many feet away is it that your agriculture land is going to be?
2,080 and then 790
Okay.
Do you mean if it were to be changed or?
Oh,
do
no,
the
no,
current-
right now, if you wanted to walk over to your agriculture land, about how far from your house is that?
It's about maybe 350 feet. I mean, it kind of slopes along the curve of the property, but it's above the depression area, an additional probably 150 feet beyond that. So like my house, my backyard, there's like a land berm, and then you continue walking up the hill and there's a stake from the surveyors for where the conservation location is currently located.
Okay, and then on your, I know that it's very windy, so of course, a lot of things are hard to grow in that. But I also, have you looked into, I mean, on that agriculture land, then you would be allowed on that land to have like a vacation rental or additional properties, develop additional houses that could be used either as resident, you could live in them, you could have them as long-term residentials, or you could petition to have them as vacation rentals. Is that correct?
I don't think that's correct from my understanding of the rules. I mean, I don't think I can actually build any other structures with the amount of, so I'm in the special management area and there's a square footage limit for structures. And while I'm in conservation, there's an even more restrictive square footage limit. So I don't believe I could build any other structures, and I don't have any intention of doing that. Don't want to do that.
Okay, okay, and then I understand up in that area, there's a lot of people historically, a lot of windbreaks were planted with large trees that could create windbreaks for protection for plantings and for housing and everything else. Do you have any windbreaks along your property that could help protect your land?
We don't right now. I mean, the tower, right? It was basically like they kept the land grazed down really short around the tower so that they could service all of the outriggers that basically supported it. So the outriggers were in all the backyards as well as around the whole circle of that tower that you see in the aerial photo. They didn't really have a lot of trees for interference with those support structures.
Okay, all right, thank you very much.
Yep.
Thank you, Commissioner Cabral. Commissioner Chang?
Thank you, Mr. Chair. I just have two final questions. Mr. Egan, again, thank you. This is based upon your responses. And you consider that the conservation regulations to be quite burdensome. Was your price when you purchased the property commensurate with conservation lands?
I mean, I think that we paid, at least for me, a lot of money for the property. I mean, it wasn't a cheap purchase or something like that. I don't think got a discount because it was partially in conservation.
How do you know that? How do you know that it wasn't discounted because it was conservation?
I looked at many other shoreline properties for sale. I considered purchasing several of them.
Okay.
So.
Okay. But and again, you do appear to be a very savvy business person, but would you agree that normally a sales price will be different based upon its zoning, that you might pay more for agricultural land or you have less restrictions than for conservation lands?
I think that's fair. Yeah.
Okay. And do you and it does appear that you've read the regulations, but what is your understanding on the purpose of conservation lands?
That's a great question, Commissioner. So, I fully support the goals and initiatives of the conservation zone. They're there to protect and provide, protection and perpetuity for important lands. The front shoreline portion of our parcel is in conservation. It, has been improved. We worked with Hawaii County and the state of Hawaii, the National Park Service, to align the Alakahakai as well as the Na'ahele Trail System, create a 10-foot wide pedestrian easement beyond the actual shoreline area so that it's easier and safer for everyone to walk on like nice, grass instead of lava rocks and things like that. So I'm a big fan. My wife's a big fan of public access of Hawaii's public shorelines and beaches, and strongly support those things. And, with what we're talking about, none of that would change. It's really just about making the part of our property that we live in and use just a clear, like simple process to live in and to use our property.
Yeah. No, I understand and appreciate, but it would change. You would be, by changing it to agricultural, you would not have the protections of conservation, or the public would not have the protections of a conservation zone land. Isn't that correct?
Well, the Mackay portion from the road would still be in conservation. So I think the public shoreline access, the things that conservation is there for, would remain the same.
And using that same argument, if the Land Use Commission, when it made its designation, looked at this property or looked at this, the swath of land around here, and determined that they wanted a greater area to be protected, shouldn't we also honor and respect that designation?
I think that's a good question. I can only say what evidence I see of how they put the boundary around where my parcel's located to infer that kind of question.
Okay, no, and I appreciate that candor. You raised something that I was not aware of. Is there an Na'alehele trail on the Mackay side of the property?
It's kind of a combined trail. So it's the Alakahakai, not the King's Trail. The Na'ahele trail system has a different name, which is escaping me, but they basically run on the same pathway through this area. And it's both north and south. DHHL doesn't as like actively address those kinds of things. So I don't know if they've gone through the process to basically record it or certify it for their part of the parcel, but it is practically used in that way as well. And then to the south, there's a different Na'ahele name as well as an Alakahakai alignment.
Is it called Alaloa, the Alaloa Trail?
I believe the Alaloa is actually above my property. It follows an old railway alignment that is actually the access road to the Mu'ukini Heiau and other sites.
Because it would make sense that there would be a Mackay trail that ran along the perimeter following the Alaloa and the Alakahakai. So is that trail that's in front of your property, is that a public? Is that owned by the state?
It's not owned by the state. There's an easement with Hawaii County for a 10-foot wide pedestrian access trail. It's kind of their standard way that anytime you request, like when I requested my SMA permit, that was one of the conditions, is that we did that, which we greatly support. And, we maintain it, mow it, make it really nice so that people can walk their dogs and go fishing. But it's not owned by them.
I'm wondering why it isn't owned by the state. But if it's a public trail that pre-existed, was pursuant to the Highways Act of 1892, it would be a public trail like the other Alaloa and Alakahakai trail that goes around Hawaii Island. It is owned by the state of Hawaii as a public trail. So I am wondering why this in front of your particular property, it is not a publicly owned trail. And if indeed there was a public trail there, that may have also been the basis upon which the Land Use Commission wanted a particular boundary, a buffer to protect that. I mean, we are only surmising what the LUC had intended, but that Alakahakai, or if it's an Alaloa or Alakahakai, all of the other properties along the Kona coast, that trail is owned by the state of Hawaii. So I do find it somewhat curious why this isn't. And I get that's not the issue before us today, but there is sufficient case law there's sufficient positions taken by the state of Hawaii, specifically DLNR. If there's a public trail in front of their property, especially one that's being used, it is owned in fee simple by the state of Hawaii. So again, that's not currently before us, but I think that that is a, that's an important issue in my mind, when the Land Use Commission might have designated this. And it may be an issue in the future because the state has, you know, they have somewhat aggressively gone out and claim property where the trails existed. So with that being said, I have no further questions, but thank you very much.
Thank you, Commissioner.
Commissioners? Okay, I have some questions for the witness. I'll just remind you, you did take an oath, yeah?
Yes.
Sorry, to start from one of the most recent things you said, you obtained a special management area permit from the county.
That's correct.
Can you explain to me and the rest of the commissioners what that permit was for?
Sure. The special management area permit was to be able to basically take the homes and repair them so that I could live here.
And when did you obtain that permit?
We started the process in 2018, and I believe it was like June of 2018 that it was granted.
And did you represent in the SMA permit at that time that you were going to be seeking boundary reinterpretation?
I wasn't aware of the issue at that time.
So the answer is no.
That's correct.
Okay. Did I understand the representations, and I'm not sure if it was you or your counsel earlier, that one of your wishes is to move this land into the agricultural district so that you can sell some of the produce from your property as is required for residents in the agricultural district?
Yes, that's true.
Okay. What kind of water service do you have to your property?
I have an agricultural metered County of Hawaii water meter.
Or you have an ag meter on your property?
Yeah, it's very expensive. The size, it's 1.5 inches instead of the normal like city size meter. So it's very expensive month to month.
Yeah. How many avocados would you have to sell, for instance, to cover one of Cal Chip Chase's hours?
I mean, I would take quite a few avocados to pay for that type of fee.
So may I surmise that you would pursue the agriculture not primarily for its financial returns, but rather because of the legal requirements involved, as well as any other sort of values that you might get from growing produce?
Well, I mean, we do have like that history. It's really what my wife loves to do. If you saw our lanai right now, I mean, she's got the entire thing covered in potted plants that she would love to put in the ground.
If I may. So yes, you like to farm. I get that.
Yeah.
Yeah, but the motivation is not necessarily solely that you like to farm. It's that you would be required to farm to validly have a house in the agricultural district. Is that correct?
I feel like you are maybe testifying for me, but
Excuse me?
it feels like
I'm
you're
asking you a question. You may feel free to answer it or not answer it, or your counsel can step in if he thinks it's inappropriate.
okay. Well, I recognize that I can't sell my produce right now because of how the area in which it's grown is zoned. And so I wouldn't be able to pursue earning money the way that it stands.
That is not my question. My question is, if we granted this and you were now in the agricultural district and therefore required to produce, you're not going to be able to realize enough money from your agricultural pursuits to make it worthwhile in and of itself. Is that correct?
That's probably true, like most parcels of land in the state of Hawaii that are egg zoned, they all suffer from very similar issues.
So you haven't done a, for instance, business plan for producing agricultural income from this property?
I actually have looked at it, including use of the pasture area for different types of crops. I mean, you know, we looked at pineapples, we thought about doing olives. We've looked at mac nuts, but the wind is too high and they're very shallow rooted. I mean, I've really looked at all sorts of different ways to generate a reasonable income from the land. It bothers me to have 17 acres and not be able to do all that much with it. So this is one that we feel like is practical and satisfying for what we want to kind of produce.
So what is the agricultural use to which you would put the land?
We want to plant the current area that grows fruit with new trees. A lot of them are very old and, like, you know, they produce, but they aren't producing enough to really be lush. And so we want to have a lot more varieties of citrus, mangoes, and avocados so that we can sell those. Those are the popular things at our farmers market. I'm not sure about elsewhere, but those are the main things that people buy here.
Okay. So, but when you testify on things as being your intention, you are one member and not even the managing member of the LLC, is that correct?
I am a managing member of the LLC.
Okay, so is your intention identical to the LLC's intention?
Yes, my wife is the other managing member who I'm describing in my conversations about what we want to do.
But as an LLC, the LLC could be owned by somebody else with the asset and its intention could change.
I own the LLC with my wife and the rest of my family.
But if the LLC were sold, the LLC's intention might change. Is that correct?
Yes, if the property was transferred to someone else, it could change. I think the good news is that the presence of conservation land on the shoreline means that any kind of meaningful, actual attempted anything would be super regulated.
So I want to go back to one other thing that came out during Commissioner Chang's questioning of you. She asked you, and I'm paraphrasing, whether or not there was any discount on the property because it was in the conservation district, and you said you did not believe so.
That's correct.
So there was nothing in any of the marketing of the property that suggested that this property was being sold at a discount because of its condition.
It was marketed as a property to redevelop into a luxury family compound. That's how it was presented. There are other properties that were basically at the same price for about the same acreage within 3 miles of this property at the time that I purchased it.
And what was that acquisition price?
It's public record. It was $905,000.
For 17 acres of coastal land.
Yes.
With housing.
There was another one for sale for $1 million with more acreage as well as structures on it. So, I mean, it's not like I negotiated the price of $905,000. It was listed for $1 million. So.
And last question for me, at least for now.
Sure.
Have you estimated what the new value of this property would be should you be successful in convincing the Land Use Commission to take your position on the boundary reinterpretation?
I have not.
Not even back of the envelope daydreaming on your front porch estimate?
I don't really think that, I mean, the property is more valuable since I improved it.
It's a yes or no question.
Well, okay, I would say no, not specifically from this action, but definitely because I have fixed it up.
Okay, thank you very much.
Sure.
Mr. Chip Chase, do you have any redirect?
I do not, Chair.
Okay. Would you walk us through how you wanted to spend the remainder of your time?
Yes, Chair. With the conclusion of Mr. Egan's testimony, the only other evidence to review is the testimony that was submitted in support of the petition. From there, I would discuss the standards that the commission applies, look at OPSD's Exhibit 4 that had come up early in the discussion, that Commissioner Ohigashi had mentioned, and make my closing arguments. And I think all of that is probably 20 minutes or so of time.
We've obviously run through lunch hour. I don't think anybody on the commission anticipated the length of your presentation today. Let me assess with my fellow commissioners how you wish to proceed. Do you want to take a lunch break, or do you want to just try and plow on through?
I need a break at least.
Commissioner Wong, we can either take a 10-minute break or like a 30-minute break.
Chair, you know where my.
I know where your stomach votes, Commissioner Wong.
Okay, thank you.
Mr. Chair, I'm good with a 10-minute, but if we take no more than a 30, that's fine too.
Okay.
Yeah, I thought the last one was our lunch break, so I ate while you were talking. Thank you.
Commissioner Giovanni?
No more than 30. Thank you.
Okay, let's reconvene at 1:20 exactly. Okay. It's 1:21. We are back on the record. I recognize Commissioner Ohigashi.
Yeah, I just wanted to apologize to Mr. Egan. I didn't mean to get so testy about it. It's just that I have some other issues going on right now, but and I want to express my concern about the exhibit, department planning exhibit number 4, and I did it wrongly to Mr. Egan rather than to the Department of Planning, Office of Planning. I apologize. That's for you, Mr. Chip Chase.
I appreciate that, Commissioner.
Thank you, Commissioner Ohigashi. Anything further, commissioners? If not, Mr. Chip Chase can continue.
Very good, Chair. Commissioners, as Mr. Egan mentioned, he did have an opportunity to talk to his neighbors, and uniformly they supported the petition and the correction. Some went so far as to submit public testimony in support, and it's part of the record, and we put some of that up on the screen. I won't read them or go through them, but I think it is important to note that to the folks most directly affected by this, they support the petition and support the correction. In terms of why we're here, coming back to what makes this the procedure that we follow. We went through, Mr. Egan, as he testified, first on his own and then with counsel, through all of the steps that the rules direct one should take before coming to the Land Use Commission on a petition for declaratory ruling to correct an issue with a boundary interpretation. Those rules are set out principally in section 22. You go down, Chris. No, next slide. But they don't start there, right? They don't start with subsection F, which is the end of our journey when we come to the commission. They start with the other subsections. And these are the steps that he went through, both on his own and then with counsel, before we presented to you on this declaratory ruling. And if you'll recall, keep going, Chris, when we finally got through all of these steps, through all of these subsections, we presented a petition that was based on staff's interpretation that the Land Use Commission had followed the old road, that was the Land Use Commission's intention in 1969. And so we prepared a petition explaining that we agree with that intention, that it's correct, it's supported by the record, but they simply relied on the wrong road. They just had an old map. Keep going, Chris. When staff's interpretation changed and they said, well, now we think the commission meant to rely on the 300-foot We reworked all of the papers. We came back to reviewing the historical evidence to say, is there anything that we can find in the maps, in the 1969 review, in any other public record? And we made public records requests that could support an interpretation along a 300-foot line. And we found nothing. We reworked our papers to address that issue, reworked our mapping, had new surveys done, new overlays prepared. And it's as a result of all the effort that Mr. Egan put in to those steps that we just breezed through on the screen. And in response to the changing basis that was expressed by staff, and nobody's fault, right? People's rationale may change. I don't blame anyone for that. But it's as a result of that long process that we come, or after that long process, that we finally come before you and present everything that we've learned. And that's why our presentation has run the length that it's run, so that we can walk you through all of this, to show you that we have done our homework, that we've reviewed all of the maps, historical evidence, that we've had surveyors survey the property, prepare overlays, not only of the property, but of the broader area. And based on all of that, we can see no evidence that the commission intended to do anything other than follow a road, or did anything other than simply put the road in the wrong location because it didn't have an updated map. And that really brings us back to this process. And I understand that it's not a favored process. I understand that. And I think you guys know me well enough that I take cases that I find interesting, and I think that my outcome is right, that I'm arguing for the correct result. That's how I feel about this case. And when I look at the precedent that supports using this process in a case like this, I come to that same conclusion. And you guys do have precedent. And the Hawaii Supreme Court, as we put up on the screen, recognizes that even agencies in adjudicatory proceedings like this one have precedent, and that precedent should guide them in future cases. The precedent you have is only just north of 20 years old. Let's go. It's the Robert E. and Christine M. Stengel case. And we presented a copy of the entire decision as Exhibit 22. And in that case, the commission amended the conservation district boundary line on the 1974 LUC map for the H59 quadrangle to reflect what it determined in that proceeding was the actual intent of the commission in its 1969 review. In that case, the official LUC map showed the conservation district line as following a 200-foot contour line noted as the top of the poly. Petitioner, after going through the steps that Mr. Egan has gone through, came before the commission and pointed out to the commission that the conservation district boundary line as represented in the official map was incorrect because the 200-foot contour line on the map did not reflect the actual location of the poly. The commission noted that the petitioners had purchased the property with the intent of building a home on it. But this fact did not prevent the commission from correcting the mapping error. The fact that they bought the property with knowledge of the error did not prevent the commission from correcting the error. The fact that it might make the property more valuable to move the line because then less land is in conservation did not prevent the commission from correcting the error. The commission corrected the error because the error existed. And that's really, as we looked at the very beginning of our presentation today, that's really what the 1969 commission intended. That these aren't going to be perfect, that there will be mistakes, that there needs to be a process for fixing them. That's the process in Stengel. That's the process today. So in Stengel, after submitting 2 boundary requests and a topographical survey depicting the accurate location of the poly, the petitioners finally sought a declaratory order under Section 22F, the same section we're here today, requesting that the commission correct the location of the boundary. And the commission granted the request in part. And in doing so, the commission relied on the intent and the action of the drafters of the 1965 review. and interpreted the conservation district boundary line as being along the actual location of the top of the poly rather than along the 200-foot contour line as was drawn on the LUC map. There was a mistake and they corrected it. In this case, all we ask is that the commission take similar action. As in Stengel, the conservation district boundary line does not follow the actual location of the physical boundary, which is the only boundary we have any evidence the commission intended to follow in 1969. It simply doesn't follow the road because they didn't know it was in that location. Instead, they started the conservation district boundary line through our property at exactly the point where they believe the old road existed. It simply did not exist in that location at that time. And we know that they followed that road because to the north of the property, they followed what they believed to be the road as it existed in that location at the time. It did not exist in that location, not only on our property, but to the north. They still followed it. They simply got the physical boundary, that physical marker that they were looking for, wrong. And having started from the wrong point, they simply continued the wrong line through our property. It's exactly like Stengel. And we can see that on the overlay in the overlay with the 1982 USGS. We can see the points, the intersections, what they meant to do and where they went wrong. We know that road existed. We know that it existed in its current location. And go ahead, Chris. We know that they followed roads. We know that the property was in agriculture. So all those data points that we have line up, property and agriculture, intended to follow roads, thought they were following the road. The road simply didn't exist where they thought it was. And so we also know that the standards the commission set out for its review in 1969 accord with the standards for the agricultural district and the conservation district. And that placing the line, the boundary line along an existing roadway was both their intent and consistent with what the conservation district and the agricultural district are supposed to do and are supposed to represent. We also know that that is consistent with the county zoning and the county's designation of the property. And so then we come then to the last document we've discussed so far today, Exhibit 4 that Commissioner Ohigashi had mentioned. When we look at this document, we can clearly see the location of the road actually surveyed, as Mr. Egan explained. We know from the aerial photographs and the USGS maps that no road has ever existed in the location of what is marked as the 1982 paved road. Never has in the history of the property. Nothing has ever looked like that. That is simply a mistake because of the limitations of the GIS software that is meant to track the existing road as it is today. What we have that is reliable are actual survey maps of our property, mapping that road, mapping the currently interpreted conservation district line, showing where 300 feet from the shoreline would be, demonstrating that 300 feet is not the metric that they use because it doesn't intersect in any material way with the existing line. So on the actual evidence, the actual surveyed evidence, we know where the road is, we know where it was, and we know where the line should be. I talked a little bit about the process, and what we've done is what the commission contemplated in 1969. It's what the rules direct us to do. It's what your precedent directs us and directs you to do. And it's what staff advised Mr. Egan to pursue. Those are the reasons that we're here. And that decision is based on your decision, ultimately. It's based on evidence. The evidence is the information that we have presented to you over the course of this morning and now into this afternoon. That evidence shows only that the commission intended to follow a road, and it just got the location of the road wrong. It shows that none of the other considerations that we've discussed, purchase prices, when acquired, all those things have ever been relevant to your decision. And one precedent that we have, none of them are reflected in the rules. None of those considerations reflected in the 1969 review. It's simply a matter of correcting a mistake. And I'll close with this, and I appreciate your time greatly. That mistake is important. It may not seem like it should be. It may seem that there should be other reasons or other solutions. I don't know. But it's important to an individual. It's important to a family. And I think that that's why they've invested so much in this. And I think that getting it right is important too. Thank you very much.
Thank you. Commissioners, any further questions for Mr. Chip Chase at this time? Let me review our procedures. We're going to have some questions from him. I'll then allow you to ask any further questions if you want to of the county or OPSD. I'll give Mr. Chip Chase a chance to rebut, and then we'll move into deliberation.
Very good.
Commissioner Ohigashi.
Mr. Chip Chase, when I read the Stengel decision, it said something about, it dealt with a situation where there was a clear delineation that it should be on the top of the poly. However, the topographical survey showed that the approximate boundary drawn was inconsistent with the top of the poly. In this case, we're dealing with an existing dirt road that was specifically identified on a map, shown on everybody's map, and utilized by the commission to draw that particular boundary. Is my interpretation wrong, or can you expand on what do you think? Where am I going wrong with that?
I'll do my best. I think you're not wrong on the Stengel decision. I think that your interpretation of the Stengel decision is the same as mine. Where I think we might differ and is really only as to the evidence here. The evidence shows, I think, as you correctly said, that they intended to follow this road depicted on the 1957 map. The difference is between you and I on that is that the road did not actually exist in these locations, not only on our property, but north of it when it was mapped. So in that way, it's exactly like the Stengel decision. We know in Stengel, they intended to follow the top of the poly. They just drew the line in the wrong place. We know in our case, they intended to follow an actual roadway. They just drew the roadway in the wrong place because they didn't have updated information. And so in the same way as in Stengel, there was a mistake made. There was a mistake made here when they drew the line.
Did the Dirtway road exist in 1957?
It existed in 1957. It did not exist in 1964 in the location that the LUC placed it.
So the dirt road that was depicted on this particular map, even though it was wrong, wasn't there in 1964, it still existed in 1957.
It did exist. Right? It did exist in 1957.
So, assuming that they intended to follow that particular road that was listed in 1957, wouldn't it make sense that the line be drawn as it is now?
Actually not, for two reasons, Commissioner. One is that there's no indication in any record from 1969 or in any of the mapping that they intended to follow roads that had at one time existed and were no longer in place. The second is we have the opposite indication that they intended to follow existing roads at the time they were mapping. And so there's no indication in any document or map or any other thing that this commission has done suggesting we know the road isn't there, we're going to follow it anyway. We have exactly the opposite indication.
And is there an explanation that can be fashioned that because the military controlled that particular area, that they intentionally drew the conservation district line above the military's particular facilities, which included these particular developments, and therefore adhere to the 1957 line, so that when it returned under state control, it would remain into conservation district?
No, Commissioner, with respect, there's no indication that that is what they intended to do. And again, there is the opposite indication. We can look at that, or we can see that opposite indication in a couple of ways. The first is that when they deviated from the roadway, we can clearly see the deviation on the map, say for Kamehameha, the first birthplace, right? There's a clear deviation from where they perceive the roadway to be. The second is historically, we know when they deviate from physical features like roads, they have said so for an area, and they don't say that here. And the third reason that we know, and I think is the most critical to understand really, is that north of our property, so north of where we are today, the road had disappeared, had been changed, but they continued to follow that approximate location into our road. And then as you see where the road turned Malka on 1957, they drew a line that simply connected it to the next point that we see on the roadway. So there's nothing to suggest any other conclusion beyond that. They were following roadways and they just didn't know where the roadway was.
What effect, I'm moving on to a different topic now. What effect does the fact that this particular request would only apply to the petitioner's property and not apply to that portion of the residence that is outside of his particular property?
It has no effect on the decision. As a practical matter, that area would remain in conservation unless the landowner sought to change it. Now, it is DHHL, which is typically not bound by the conservation district line anyway. So I don't even think practically it necessarily has an effect, but it certainly doesn't have a legal effect on the decision today.
And I should have asked Mr. Hagan, but is there any agriculture going on the other 14, somewhat, or the 12.28 acres, I think, or 14 point something acres that are in agricultural land right now?
What we've presented, and I think Mr. Egan testified, is that that area of the property is used for grazing.
And I'm not sure if he answered the question or anything like that, but, or if you can answer the question, is that you mentioned there were like 10 cows or something on that. Is that his cows?
I mentioned, yes, Commissioner, I'm sorry to speak over you. Yeah, I think that was me. And when I've spoken with Mr. Egan, I've asked him who owns the cows, and he advised me that they are his cows. I'm sure he's still on and could answer that question if it's not clear.
No, I just was curious about that. And besides, has there been any attempt to do additional farm on that particular area?
Yeah, Mr. Egan did testify a little bit about that today. I believe in colloquy with the chair, though I might be mistaken, about the other kinds of ag that he has looked at for that Malka upslope portion of his property.
Well, why don't you refresh me? Why don't you tell me has there been any other ag done besides that for that particular area?
Oh, not done. And so if I said done, then I made a mistake. I said he looked at, he contemplated doing other ag. And as I recall, one of them was macadamia nuts. Another one was olives. I think he looked at some other type of produce or growing operation up there, and for one reason or another determined that it wasn't immediately feasible.
And so the only area feasible would be this 1.8 acres.
That is Mr. Egan's testimony, and that is my understanding, is that this area of the property is uniquely protected from the wind in the area, and so that it is better suited for growing fruits and vegetables than the other portions of the property. And that's consistent with the historical use of the property, which historically, based on the records we've shown, was in grazing. And then when it was owned by the Coast Guard, they grew fruits and vegetables in that same area that Mr. Egan would like to use for a more commercial agriculture operation.
I don't have any more questions.
Thank you, Commissioner.
Thank you, Commissioner Ohigashi. Commissioner Chang, followed by Giovanni.
Thank you, Mr. Chair. Mr. Chip Chase, you would agree that under 15-15-22, it is within the sole discretion or authority that the interpretation of district boundaries is by the Land Use Commission.
I would agree that the Land Use Commission is the ultimate interpreting authority. I would say that its interpretation is not really a matter of discretion, but is based on the evidence presented to it.
But you would agree that weighing the evidence, determining its credibility, that's really within the authority of the commission.
I'm not sure I would get that far, Commissioner Chang, on a declaratory petition or petition for declaratory ruling. The facts are undisputed because there is no opposing party. So the facts that we've presented in the form of the testimony, the presentation, and the exhibits, and I haven't forgotten, Chair, to move in my other exhibits. I'm just waiting until we're done with questioning, is the evidence before you. And so those facts for purposes of a declaratory ruling are not in dispute.
Okay, but you cannot, I mean, you wouldn't dispute the fact that OPSD has taken a different interpretation than the petitioner.
With respect to how I have understood OPSD's position is that they've simply concluded there wasn't sufficient evidence to show that that a mistake was made. That's not in itself evidence. They're not a party to the proceeding. They've just offered their comment on the evidence that has been introduced. The map that they provided is Exhibit 4. With respect, I think we've demonstrated is not correct. But because OP is not a party to the proceeding, that map itself is simply OP's commentary, not evidence before the commission.
But you didn't object to Office of OPSD's, either their testimony, or I don't know if we may not have answered their exhibit, but you had not opposed the procedural instructions provided by the chair that OPSD, like the county, would have the opportunity to present their own arguments, right?
Well, up to your last sentence, I was completely with you. I didn't and I don't. They have absolutely the same right as the county to comment on the petition.
Okay. And it is, so the kuleana or the, within the parameters of the commission to weigh all of those, all of the evidence and the arguments by the various, I know it's just the petitioner, but to also take into consideration OPSD and the county.
Well, I think you definitely consider OPSD and the county's comments. You don't consider them as evidence.
Okay, fair enough. All right, thank you so much. I don't have any other questions, Mr. Chair. Thank you.
Thank you, Commissioner Chang. Commissioner Giovanni.
Thank you, Chair. I just have a couple logistical questions to clear up, and maybe Mr. Chip Chase can help me.
Try.
So, what was the year that you suggest that the mistake was made by the commission?
1969.
What year were the houses that the petitioner now occupies? When were they built?
1961.
So when the commission made their mistake, they were surely aware that the houses were there. Is that correct?
It does not appear so. I have no basis to believe they were.
Say that again?
Well, I have no basis to believe that the commission was aware of the homes. It may have been. I'm not denying that that's possible. But as I look at the record in the 1969 review and the map that they used as a base, there's no discussion of those homes, and there's no indication on the map that they used that those homes existed, even though they did.
Well, it's very, I'm not going to enter into the war of conjecture about what their intent was or what they may or may not have known at the time. I'm going to try to rely on the evidence to make my decision. So thank you very much.
You're welcome.
Thank you very much, Commissioner Giovanni. Commissioners, anything further? Mr. Chip Chase.
I would be disappointed if you didn't have questions, Chair.
So you've had the opportunity to observe me in action for a few years now.
Indeed.
You might guess one of the things that's disturbing me. I understand that a lot of this hinges on, whether or not an error was committed. But the discussion is strangely absent from the actual practical implications of a ruling one way or another. I have not visited this property. I am unaware, and the record is kind of silent as to whether whether it is view planes or below ground resources or other ways in which the land, which is currently in the conservation district, doesn't actually meaningfully contain some values that we would want to protect in the conservation district, and whether or not there would be harm that would occur to the state and to the public trust as a result of this interpretation, even if we took the position embracing your argument saying, yeah, they got it wrong. But even if they got it wrong, it's possible that they should have done it differently to actually protect meaningful things. Where are you suggesting, by narrowly focusing your argument merely on the way the maps were drawn, that those considerations are completely outside of what we need to consider in our deliberations?
It's a thoughtful question.
If I haven't been clear, please ask for clarification.
Oh no, you're clear, Chair, and I understand where you're coming from as well. And if you'll indulge me in my answer, I would say I partly would say that those are not considerations for the issue that is before you. They might be considerations, indeed they are considerations, on a district boundary amendment. But when we're looking at an existing line and simply determining whether that line was drawn in the wrong location, in other words, we're interpreting where the line was meant to be drawn, those are not considerations that are reflected in the 1969 review, in the rules, or your precedent. And so I would say that they are not a proper basis for an interpretive decision, as opposed to a relocation of a boundary. But as to your premise, Chair, I would say with respect that there is evidence of the actual use of that property, including its topography, in the record. The actual use of the property we know is a roadway. We know that that roadway services not only our property, but at least DHHL's property as well. We know that there are homes located on the property, and we know that those homes have been there since 1961, before the conservation district was mapped. We know how the property malka of that is used. It's cultivated for personal consumption and use. And we know the general topography of the property, that the area where behind the homes, there is a dip in the land, and that it slopes up and then is generally more exposed to the wind. We also know that all the agencies had an opportunity to comment on this. That's attached to OPSD's submission. And with the exception of OPSD, no agency took a position on the petition, including DLNR. And so we know from the evidence that is before you that there's no indication there are any resources in this 1.8 acres that include an improved road and 2 homes, that there are no resources or other values that reflect what the conservation district is and is meant to protect.
Thank you for your response. Commissioners, anything further? If not, I want to make, as I indicated, commissioners, do you have any questions for the county first? Seeing none. Questions for OPSD? Commissioner Ohigashi.
Yeah, I'm kind of disturbed about your exhibit number 4. Could you explain what the purpose of exhibit 4 was?
Purpose of exhibit 4 was to show the 1959 dirt road and the approximate location on the property.
1957, or is it the 19?
The green line. That was the main purpose of exhibit 4. And the other lines are just generally to show where those other things are in relation.
So the 1982 paved road is not located where it's located. Are you stipulating to it that it's in accordance with what the petitioner had done?
That this overlay was done just by GIS on their best efforts to make it match. But the purpose of it was to see where the 1957 dirt road ran on the property. It was not to say that the paved road is not where the petitioner says it is.
So are you saying that the 1957 dirt road is accurately portrayed on your exhibit 4?
As far as I'm able to tell, yes.
And
again, this was prepared by GIS. I am not an expert on this, but the purpose of this exhibit is to locate where approximately that road is, because we weren't sure if it actually went through the property or if it just, as you can see, just goes through a corner of it. We are not suggesting that the paved road is in a different location than where it's shown on the survey. That was not the point of this exhibit.
is a blue line accurate?
Yeah, it looks like it's exactly on the same line as the boundary interpretation and survey.
So what I'm going to take away from this exhibit is the only line that appears to be inaccurate is a 1982 paved road line. Is that right?
I cannot say whether it's accurate or inaccurate. This is what we received from GIS. This was their best efforts to show us where things are located.
Well, it seems like kind of
Based
far
on the
away.
topographic maps.
Okay. Well, it's more confusion than anything to me.
Mahalo, Commissioner Ohigashi. Commissioner Chang.
Thank you. Ms. Kato, Mr. Chipchase just said that DLNR did not object, but in looking at your exhibit, Division of State Parks, under which Na'alehele presides, I do not see them as being checked off. Do you know whether the Division of State Parks had any comments to this petition or this action?
I am not aware of any additional comments, just that they did not, the ones that are checked off had no comments at all.
Because the petitioner did admit that there is the Na'ala, well, there is a Na'alahele, there's a trail system that goes in front. Wouldn't you agree that that is a cultural or a natural resource?
I'm not familiar with this trail, but it would have been something that would have been good to know. I don't know where this trail is located. I've not heard of it before. I think that is possibly another consideration as something that may have been another reasonable explanation for the location of the boundary. As you mentioned, if there's a trail, maybe there was a buffer, they could have considered that at the time. But you know, there are multiple reasonable explanations other than a roadway. And I'm actually, there is one point that I wanted to mention. Mr. Chipche stated that the first LUC boundary interpretation stated that the boundary was based on roadways. But in the October 2020 letter, I did not see anything that mentioned that it was based on roadways.
Okay.
So that's just something I wanted to know. I'm not sure where that is coming from.
Okay.
And OPSD has not seen any actual support for the assertion that the boundary was intended to follow the roadway.
Well, I just wanted your clarification that the Division of State Parks did not respond to your requests. So we
They
don't
did
know
not
what their position. Okay,
That's correct. They did not respond. And we did not know about this trail before the hearing.
all right, very good. Thank you so much. I have no other questions.
Okay, commissioners, further questions for OPSD? So if I may, Ms. Kato, if I misheard you, please correct me, but your last statement was you have not heard any evidence that the LUC's original placement of the boundary was based on the roadway, so you're disputing what Mr. Chipchase has offered?
That's correct. I mean, I don't know that there's any, we have not seen any actual support that the boundary was intended to follow a roadway, other than look at this map, the roadway looks kind of in the same area as the boundary line in certain places. This road, there is no roadway south of the property. So when you look at the property, there's no roadway south of the property, and the old dirt road didn't even cut across through the property.
Help me. What kind of evidence do you think the petitioner could have provided that you would have been like, ah, yeah, clearly?
Well, for example, the Stengel case was mentioned, and the Stengel case, I think, had a specific note saying that it was meant to be a type of poly. And it's just, they misunderstood.
And other than the broad guidance in here, there wasn't a specific mention.
Yeah, and the broad guidance didn't even state that it's supposed to be on the roadway. It just stated that that area was full of, you know, historic areas that should be preserved and in the conservation area. Also, you know, he's also relying on the condition 1 for those 4 conditions that are listed in the report, the 1969 report. But the 1969 report, we understand, was not actually adopted by the LUC. The map was the official adopted document, not the report. The report just provides a record of what happened and background information. And also, we don't think that the has been shown that condition 1 has been met, because condition 1, of course, is a road at the edge of agricultural use, meaning it separates agricultural use and non-agricultural use. There's just been kind of general maps showing the area in general was used for pasture or grazing, but not that that paved road actually divided agricultural use and non-agricultural use. And also the constructed buildings were Coast Guard buildings. They were for crew housing for, I think, residential housing for married crew members. And those buildings existed in 1969, Malka of the road. So it kind of doesn't make sense to say that the Coast Guard buildings constituted agricultural use.
Thank you. Anything further, commissioners? If not, I'll give Mr. Chip Chase a final chance to say anything and any other questions. Commissioner Cabral, is this for Mr. Chip Chase or for OPSD?
No, actually, I'd like to go back to Ms. Campbell with
Okay.
Hawaii County. And am I understanding it that Hawaii County Planning Department or your Corporation Council is not taking any kind of position on this?
That's correct.
You know, it's our island. It'd be nice to have input. So that's just my opinion. Thank you.
Okay, if you want me to clarify a little bit, as the petitioner and Mr. Egan have both stated, the entire zoning of the property is currently Ag 20. And so moving this line either further Malka or Mackay doesn't really change the Hawaii County zoning. And we do defer to the authority of the Land Use Commission to make state boundary changes. That's really the kuleana of the LUC, not of the county.
Okay, well, I definitely appreciate the opinion, information. Thank you.
Yeah, thanks.
It does make me want to ask Ms. Campbell, if the parcel is less than 20 acres and if it's Ag 20 and there was not an existing house on it, say the entire thing was in the Ag district and it was 17 acres in Ag 20 zoning, what would be the rights of the landowner to develop a agricultural related unit?
You know, I would have to look into that. I have to admit, I don't know off the top of my head. Obviously, it would be a non-conforming lot. I am unaware of how these lots were formed. It does not seem to be consistent with the use of the property. I think either Mr. Chip Chase or Mr. Egan noted that at some point in the past, obviously the Coast Guard did not pay attention to their own lot lines when they were making use of the property, and they dropped a home right across a lot line. So I don't know how these lots came into existence. This one clearly, as you know, 17 acres in an Ag 20 zoning is a non-conforming lot.
Thank you, Ms. Campbell. Anything further then before we go to Mr. Chip Chase? And I can do this before or after Mr. Chip Chase, but I did recall a question I had for you that was a minor one, but I
Please
just
go
wanted
ahead,
some
Chair.
clarification on.
Yeah.
You know, you had the news article that talked about the open house and for the rebuilt Coast Guard station, and cookies and cake and ice cream was served afterwards. In that article, and I don't have your exhibit number in front of me, but it actually described that a new road was built from the Upolu airport to the property. That's to the north of the property. So I'm not understanding the argument that you're trying to make that somehow that would affect the road on the southern end of the Coast Guard property.
Yeah, it's actually a great question, Chair, because it's clear that I haven't been clear in what I've been trying to explain. And that is that the new road extended beyond our property to the north. It went farther north than our property. And so yet we know that the LUC in 1969 used the location of the old road, the alignment of the old road north of our property when it mapped its boundary. And so we know that not only with respect to our property, but with respect to the other properties in the area, it intended to follow a road. It's just that the road was not in the same location, either on our property or to the north. As for the chair's question about the southern portion of our property, and I'll pull up an exhibit in a moment that I think illustrates this more clearly when we're done with the questions, but the road curves through the property as realigned and goes along the southern edge of it. So as realigned, it did go from that area up north all the way through the property before curving Malka.
So I guess just Exhibit 14 states a new road leads to the station, taking the place of the former drive by the Upolu Point Airport. So I don't understand how this exhibit makes your case, because it's discussing a road from the north to your property, not through your property.
But and we have other evidence in the record, Chair, that I didn't. Exhibit 13. Exhibit 13, Ms. Olds points out to me, discusses the road through our property in 1961. Would that be right, Ms. Olds? Yes, in 1961. So it was all the same road realignment. And when it was realigned and these units were constructed, as Mr. Egan testified in 1961, the road ran in front of them, just Mackay, and then up the southern boundary.
And so, Mr. Egan, you've been spared appearing in front of the LUC for all the previous portions of your life. So this isn't just right now, we're just working with your counsel. So. Mr. Chip Chase, why don't you continue?
Very good, Chair. I think I'll start with a point that Ms. Kato made, and that is the basis of the LUC's the staff's original interpretation. I spoke with staff extensively about the basis for the interpretation and the actual location of the roadway. And it was represented to me that it was based on the location of a roadway. And if you look at our first petition, as I know Ms. Kato has and has possession of, it's entirely based on that interpretation, because that was the interpretation we were told served as the basis for the line that was drawn through our property. And if you look at the docketing history, you can see that that petition was set for hearing some time ago, but the hearing was continued because staff issued an errata, changing the basis of its interpretation from a roadway to 300 feet, yet the line did not move, right? The only reason to issue the errata is because the basis for the interpretation changed, and I spoke with staff after that. I totally understand. People look at things differently. They come to different conclusions. We took it into account and refiled a supplemental petition to address that change. But absolutely, the initial basis was that it had been located all along a road. That's the only reason that errata was later filed. The next thing that I want to talk a little bit about is the Stengel case. And in doing so, I'll have Chris put up one of the overlays. And this is, Molly, what exhibit is this? She'll look it up real quick. There we go. So this is exhibit 20. Nope, she's correcting herself. This document is an overlay prepared by a surveyor. We're entirely confident in the location of the lines, to Commissioner Ohigashi's point. And as you can see, the district boundary that the commission drew to our property and north of it is entirely coterminous with where they believed the road to be, except when you get up to Kamehameha I's birthplace. It doesn't casually intersect. It doesn't maybe kind of closely align. It entirely aligns, right? It says Exhibit 8. And so just as in Stengel, we know directly from the map what the commission thought it was following in 1969, a roadway, because the line they drew is entirely coterminous with the roadway all the way into our property. And then once they get to our property, they just generally continue that direction through the property and south. And if we looked at the map, and it's been earlier up on the screen, it connects with another roadway to the south. That is everything and more that Stengel had. And we know that when they drew this, they just used the wrong map, because we can see from the baseline, the 1982 USGS, that's not where the roadway was for the bulk of that length. It had been realigned to the north, into our property, through our property, before turning Malka. So we have exactly the same textual basis that Stengel had. A clear indication on the map of what the commission was doing and intended to do, and a clear indication that the road they thought they were following simply didn't exist in that location at that time. As Ms. Kato mentioned too, you can take it down, Chris.
Excuse me, is that exhibit 20?
Exhibit 8, Commissioner.
Oh, I thought you said 20, that's why.
I did. I was wrong. Molly fixed it. It's exhibit 8. The record, and if you will, the legislative history, for lack of a better description, is not limited to the general statements of what the commission did in this district. Those absolutely indicate that the commission was following physical boundaries and not a mathematical computation from the coast. That is true. But they also had their express conditions, which included that roadways were the most favored condition under the circumstances set out in the condition. And there was a progression, making 300 feet from the shoreline the least favored of those conditions. In terms of the use of the property, we not only have the maps showing agricultural use, pasture use, we not only have those Coast Guard records that showed they were buying agricultural property. We not only have the commission's statement that the land was agriculture. We have the fact, as Mr. Egan testified, that the Coast Guard also used this area up to the Malka edge of the homes for agriculture. So it meets all of those conditions that the commission would have followed in condition 1, its primary motivating condition. And you stack up all of that on one side of the ledger as evidence for what the commission intended to do and the mistake that was made. And on the other side of the ledger, there's nothing but conjecture. Maybe they meant this, maybe they meant that, but there's not a single document, not a single record, not a single map that supports any of that conjecture. And so when faced with a record that clearly shows that a mistake was made, and it's not even clearly, it's just more likely than not, if you were to apply any sort of standard to this, it's just more likely than not, a mistake was made. The only thing to do is to correct that mistake. And to Commissioner Ohigashi's point, we recognize it only corrects it for this area. But we wanted to show you for this particular property. We wanted to show you the potential effect more broadly so that you understand this is not a significant matter. This is not something significant to Mr. Egan and his family for sure, but not significant in terms of the impact or potential impact to the balance of the conservation districts. You heard Mr. Egan testify, he's looked at all of the districts and hasn't seen an error like this before. And frankly, I haven't either. And so based on the record that is before the commission, we respectfully submit that the right course, the best course, is to follow the process that's been laid out, follow the precedent that you have, and correct this mistake. Thank you very much for your time today.
Okay. Anything final for Mr. Chip Chase, commissioners? If not, we're gonna move on to deliberation. Okay. So I'll remind everyone who's listening that this is a hearing on a request for a declaratory ruling. As such, the decision of the commission will be made on the written briefs on file, posted to our website. Oh, hold on. You lied to me, Mr. Chip Chase. You said you were going to actually ask for that exhibit to be admitted into the record prior to the end of our proceedings.
Chair, you and I are scarily on the same wavelength because it occurred to me at the moment it occurred to you, and that makes me really nervous. But I will pass on that and simply ask the commission to receive into evidence exhibits 35 through 39, plus this PowerPoint presentation to be submitted following the proceeding, as is my normal practice.
The chair has no concerns at this point with entering them in, despite the sort of larger concerns of the last minute entry of them. But I think we've spent enough time on them to be familiar with them. Anybody concerned? Seeing none, I'm going to enter those into the evidence. And so I will remind Mr. Chip Chase that while great minds think alike, my father-in-law reminds me that also the not so great minds think alike as well.
Noted.
With that said, The decision of the commission will be made on the written briefs on file and posted to our website. This is not an evidentiary hearing. Any oral presentation made today and any public testimony will be considered in our decision-making process. According to the commission's administrative rule, section 1515-100, within 90 days after receipt of a petition for a declaratory order, the commission shall either deny the petition in writing, stating the reasons for denial, issue a declaratory order, or set the matter for hearing, as provided in section 1515-103 of the commission's rules. In addition, section 1515-102 provides that the commission for good cause may refuse to issue a declaratory order by giving specific reasons. The commission may so refuse where, one, the question is speculative or purely hypothetical and does not involve existing facts or facts that can be expected to exist in the near future. Two, the petitioner's interest is not of the type that would give the petitioner standing to maintain an action if the petitioner were to seek judicial relief. Or three, the issuance of the declaratory order may affect the interests of the commission in a litigation that is pending or may reasonably be expected to arise. Or four, the matter is not within the jurisdiction of the commission. So during our deliberations, I will not entertain any additional input from the parties or the public unless those individuals or entities are specifically requested to do so by the chair. If you are requested to do so by me, you will limit your answers solely to the questions asked. Commissioners, let me confirm that each of you are prepared to deliberate on the subject docket, having reviewed the record at hand. After I call your name, please signify with either an aye or a nay that you are prepared to deliberate on this matter. Commissioner Cabral. Commissioner Cabral. You're nodding your head. There we go.
Hello? Yes, yes, yes. Oops, I'm sorry.
No problem. Are you prepared to deliberate on this matter?
Yes, yes, I am. I have a new hearing aid too.
Sorry. Commissioner Chang.
Yes, aye.
Commissioner Giovanni.
Aye.
Commissioner Ohigashi.
Yes.
Commissioner Wong.
Aye.
The chair is also prepared to deliberate on this matter. Commissioners, what is your pleasure? Commissioner Wong?
Yes, Chair, thank you. I would like to make a motion to, sorry, I don't know how to say it properly, as everyone knows, to say no to the request to move the line, to change the lines. I'm sorry, you have to say more eloquently than me, Chair, but it's like.
A motion to deny the petition.
Yeah, correct. Thank you, Chair.
Would you, we'll see if there's a second, and if there's a second, I'll ask you to speak to your motion. Is there a second? Commissioner Chang? Sorry, I'm going to ask you to go orally on the
Yes,
record.
I'm sorry. I second Commissioner Wong's motion that was eloquently stated by you.
So I'm going to ask the movant and the seconder to speak to their reasons for making the motion.
Yeah, Chair, thank you. I heard all of this information from Mr. Chip Chase and his client, plus hearing OP's statement and looking at all the records and exhibits. And I feel that, looking at all the exhibits and everyone's motions, I believe in the statement that OP stated, which is usually very rare, that there was not enough evidence to me at this point in time to support Mr. Chip Chase's motion.
Thank you, Commissioner Wong. Commissioner Chang?
Yes, thank you. I am going to support this motion for several reasons. One, I am concerned about, we do have an existing, we have had a similar petition that came before us. I think it was the church declaratory request for declaratory interpretation of a district boundary amendment, a boundary amendment. So I am concerned about, one, we have an existing potential litigation. Two, notwithstanding the petitioner's argument that this really wouldn't affect anybody, I don't believe that's necessarily the case. We don't know whether Department of Hawaiian Homelands or any of the other adjoining landowners or other similarly situated properties may raise similar issues related to an interpretation of a previously determined boundary amendment. And I disagree with with the petitioner that a mistake has been made. I think the records speak for itself. I think the map is the map that was filed, that has been in existence, is the guiding document. I also believe that the petitioner bought the property knowing that it was conservation. And when it became a little more difficult, the regulations, I don't know at what point in time he realized there was a mistake, but apparently up until his meeting with OCCL, he understood the property to be conservation. So for all of these reasons and the testimony that's been provided, I believe that there has not been a mistake, and I support the motion to deny the petition. Thank you.
Thank you, Commissioner Chang. Commissioners, we are in deliberation. There is a motion before us to deny the petition. Commissioner Ohigashi.
So I thought about this a lot. And I kept looking at the exhibits. And I was kind of concerned, but in the end, when I took a look at Exhibit 8, as Mr. Chip Chase showed, I looked at the fact that this road that went through the property, actually went through the property that they are claiming that, which appeared to be built by the United States government. There was a divergence that occurred far from it. In other words, it seemed the old road became the new road, but the old road was followed. I don't think that I think it's reasonable to conclude that the commission at that time indicated that there was that to use the old road as a standard in this case. It would appear to me that we have a case that is not like Stengler, where there was a specific reference to landmark, a landmark that could be, that was supported by meets and bounds, and could be surveyed. In this case, there was it seems to me that there was an intentional intent to follow the existing old road as was listed. What supports this more than anything else was the fact that these structures were built in 1961 and would not be considered agricultural use under any definition. So I think that the commission, I think it's reasonable to conclude that there was not a mistake made, and that based upon the existing evidence, it appears that the old road was followed for a reason. Therefore, I cannot support granting a petition in this case.
Thank you, Commissioner Higashi. Commissioner Giovanni.
Thank you, Chair. For me, I have a very high bar when it comes to the LUC making a change of a district boundary from conservation to agriculture or other. And I always look to a DBA as being the proper course of action. In this case, they're looking for a simple declaratory ruling that would remedy the situation from the perspective of the landowner. I get it. I understand it. It is a simpler course of action. But for me, the case would have to be overwhelmingly compelling because I have such a high bar when it comes to conservation land. I think that Mr. Chip Chase put forth a reasonable explanation. I think that it'd be possible to put forward contrary reasonable explanations, and I think OP has done that to some extent. I really believe that this matter would be, if the landowner is so inclined to pursue it, would be better and more appropriately addressed by the LUC in a DBA. I know that's more complicated, more expensive, but that's the risk you take when you buy conservation land. I will be supporting the motion. Thank you.
Thank you, Commissioner Giovanni. Commissioner Cabral.
I am truly confused. I absolutely understand their desire, and they as individuals, as the current homeowners, God bless all of their reasonings and their wants and their desires and their respect for what they're doing with the land. And I got it, and it's wonderful, and that's what they're going to do. And I can appreciate that Mr. Chip Chase has done this unbelievably good job of showing us so many roads and so many ways that a decision or a mistake could have been made. He's got me confused. And but on the other side, I'm really concerned that, this was a long time ago that this designation was made, and now somebody buys it, and now we don't like the hassle that it is to be in conservation. We've had several of these come up to us, and man, if every time somebody buys it in conservation and then they want to have us change it, we're never going to have it, but we will be 7 days a week doing these hearings. So I'm just concerned about it on both sides, and I'm still a little conflicted, but at this point, I'm probably going to support the motion. Okay, thank you.
If I've learned one thing over the years, is the things you think are going to be simple are complicated, and the things you think might be complicated, they're simpler. Mr. Chip Chase has put on a very good description of things. And I don't doubt for 1 second his sincerity that he believes in his argument that an error was made. I liked the petitioner. I like their plans. I think that's not relevant at all to our deliberations at all. I don't think, I instinctively believe that public trust considerations have to be incorporated into all of our deliberations, but I'm not exactly sure here on this one how it is. And so really I put those aside and really do focus on the issues at hand. And the one part where I feel that the petitioner's argument sort of fatally falls apart is that, well, indeed, I'm sure in some historic period before the Coast Guard station was there, some of these lands were used for grazing. At the time the petition or the boundary determination was made, it's undisputed from the record that there was housing on the area. And for the roadway to be used as the boundary line, I think OPSD stated correctly that it was when that was a distinctive boundary between agricultural and non-agricultural uses. And so I don't think that you can sort of rely on that condition, that first guide in this case, even if some of the land around the houses by secondhand testimony from the petitioners, the petitioner states, oh yeah, we grew some stuff around there. That's not a high enough sort of evidentiary bar that this road as existed in 1961 was truly the line between ag and non-agricultural uses. So I look at the ledger as beautifully described by Mr. Chip Chase, as slightly different. There's indeed some things on one side of the ledger indicating this might have been a mistake, but there's also things that indicate it might not have been a mistake. So that said, it's not an easy one. Anything further, commissioners? If not, Mr. Ordenker, would you please poll the commission?
Mr. Chair, and if you'll indulge me a little bit, I want to clarify Commissioner Wong's motion. The motion is to deny the petition such that the LUC's original boundary determination is deemed correct. If there are any commissioners that have a problem with that, please let me know.
Let me check.
No problem, Chair.
Movant, seconder.
Oh.
Ms. Chang.
No, I concur with the clarification.
Okay, anybody who's spoken to the motion disagree with the clarification of the motion? Please proceed, Mr. Ordenker.
Thank you, Mr. Chair. Commissioner Wong,
Aye.
Commissioner Chang,
Aye.
Commissioner Giovanni,
You're muted.
My apologies. I vote aye.
Commissioner Ohigashi,
Aye.
Commissioner Cabral,
I'm agonizingly gonna vote aye, because I'd like to see this be a nice outcome for the petitioner and their desires, but I think in principle I have to vote in favor of the motion. Thank you.
Chair Schroeder.
Aye.
Thank you, Mr. Chair. The motion passes unanimously with 6 affirmative.
Wow. There being no, well, thank you to the parties.
If I may,
And-
Chair, Commissioners, just real quick before you sign us off, I appreciate your time and attention today. Obviously, I'm disappointed in the outcome, but I thank you all for your thought and the time that you spent with me. And I wish everyone a happy holidays.
Thank you, Mr. Chip Chase. Happy holidays to you and your client as well. And I hope you do feel that we gave you all the time that you needed.
I do feel that way.
Okay. There being no further business for today, we will recess until 9 a.m. tomorrow for the continuation of our agenda. Good evening.
Hello.